Hypocrisy.
Hey, what's up, guys? Welcome to Law Explaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. We're live. Court is live. Here we go.
No burden of proof in this case. Does not have to put on a case, but I hear that you are. So your first witness, please, Mr. Jackson.
Thank you, Your Honor.
Where she sounds so depressed.
With the court's permission, we would ask that Matthew DeSoto join us.
Okay.
Okay. Well, good morning. I'm getting everything set up. Sorry, I overslept a bit, but I didn't miss anything, it looks like, which is cool. By getting things set up, it means I'm rolling on my sleeves.
You so much read the evidence you give to the court and jury in the case down here, and for the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Micro-peen counter's a lie. Give me some of them closed captions, baby.
All right, Mr. Jackson, whenever you're ready.
Thank you. Mr. DeSoto, could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew DeSogra, last name Disogra.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the
He's got a
field of
licensed
accident
engineer.
reconstruction. And within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data, and event data recorders.
Staying on that
All right,
topic,
we got
what is your current
super
title
tips
and
coming in and
position
everything.
with Delta V?
I am the director of engineering for our
Play 'em
EDR
at,
services line.
What does
appropriate
EDR
times.
services mean?
So event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the director of engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify.
Practicing
On
engineer
top of
sounds
that,
so weird. You're just
in the
an engineer.
director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in
Suppose I should tweet out
EDRs.
there
So
live.
I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing. So we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense. And as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because
And-
ultimately, sorry.
No, please finish.
Ultimately, anytime we're doing EDR data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
It's not as good as
Beyond
Lexus
Toyota being a
data.
common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe you're.
So Lexus is a Toyota brand. Right?
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term, which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit. What about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data. As
Larry
a whole
Keller,
at this
I'll do
point, and we
I'll
run
try and
into it
do
in a lot
recap
of different
tonight.
places. We see GPS data from infotainment systems, so we're
Of today.
analyzing that data. Most of that's GPS based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them. So we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is a mechanism to figure out where on earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota/Lexus, versus a heavy truck or a heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature? Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these
What's up, D.
parameters.
Jones?
We can do some maneuvers with the vehicle. Then we
Mike
can
Porter,
download the data
welcome to
that the
Paralegal.
vehicle stored, and now
Did I
we
say
can
that
compare
earlier?
the two and say, okay, well, if we have really high confidence in our system,
at 5 a.m.
how
never mind.
accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems in many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
Bro,
What
really
is clock
welcome to Paralegal.
Clock alignment
Thanks
would
for
mean that
joining up.
anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta D?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you've just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director a director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead.
Oh,
The road is open and it's yours.
certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you got both a Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
2011.
Yeah, that is a
And you
wide
have a
ass
master's.
tie.
Correct,
In engineering.
that is correct.
And when did you secure that degree?
That tie
2013.
needs the big slab. It's a double
You just
wide.
mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education.
Do you regularly attend symposiums or symposia, I guess is the right
Yes,
word? Have you attended symposia related to EDR research and training?
yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data? I'm sorry, have you attended data? Have you attended events that deal with data, event data recording systems, and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level. And then they offer certifications for that.
Are you a member of the Society of Automotive Engineers?
I am active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I am. I am currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Oh
Are you a
shit!
member of any subcommittees?
I should go visit
within
him.
that
Except
organization,
everybody in
within the
Wisconsin gets
organization
murdered.
Of the Society for Automotive Engineers.
I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does. And it requires, as far as I know, when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field?
Yes.
No.
Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Yeah, Mr. Miller, he can, well,
Have
unless
any of your peer-reviewed articles
the state objects,
you've either authored or co-authored?
he can lead him through
specifically
the
focused on Toyota
CV. They often will
Yes.
let them do that just
Can you
because it's
name one, please?
easier.
Specifically, this year published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components, it's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an EDR, an event data recorder, Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have a infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
In that research, we introduced a new technique for getting data out of damaged modules. So, you know, they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. And we demonstrated we could basically do it ourselves if we wanted to.
Mr. DeSogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR data retrieval? And recovery?
Yes.
How many times?
Once.
When was that?
In New York.
That's
You were deemed
where.
qualified as an expert in that court in this field that you're talking about today.
Specifically with as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shannon Burgess with Aperture LLC.
Yes.
Are you familiar with Aperture?
Yes.
Before you were asked to undertake that review, were you familiar with Aperture?
Yes.
Were you familiar specifically with Shannon Burgess?
Yes.
Were you asked to engage in any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Ms. Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you in fact review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2, 1162-2.
Yes.
Did you determine whether Dr. Welcher had based his report on Shannon Burgess's analysis?
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events. So we're all talking sort of with the same vocabulary if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming, that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
For which event?
For the 1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to
permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor. So the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Objection.
Sustained is to form.
Let me ask you this. Does a trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself?
Yes.
Explain that for the jurors so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording. And as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Sustained is to form.
What? Why?
Is there any, if a trigger event is one point
That's
in
not a
time,
leading question.
one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that
That's
long.
my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long,
Right.
correct?
Correct.
So in other words, it captures, or does it, let me ask you this, does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event.
Of the recording event.
Not
So,
the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted
It's been
that would
noted.
be 5 seconds inaccurate. I'll withdraw it. I'll ask it a different way. What would be the effect of timing if you were to start at the trigger event 12:31:38 versus timing the event if you were to start at 12:31:43?
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a lock event, which you reviewed, at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to
What's the cat
the
artwork?
offsets
It's just a
that
funny
you
moment.
identified in Shannon Burgess.
where a lawyer's
time offsets that you
granddaughter
identified in Shannon
Got the cat
Burgess's
filter
report.
on his Zoom. And so he showed up
When
to
you
Zoom
apply the
court.
potential offsets
cat.
identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Just say it was bullshit.
Sustained, ask it differently.
Did you apply the potential offsets identified by Mr. Burgess in his January 2025
I love how
report?
Hank
to the
doesn't
text
sound
stream event
confident in his objection,
1162-2?
and Bev
Yes.
doesn't know
Did
how
you
to
also
sustain it.
apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask a different question. With regard to the original report, the January 2025 report,
That
was
was
there
leading
any
question.
circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it differently, Mr. Jackson.
what is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Objection. Sustained. When did the lock event
May
occur?
we approach, Your Honor?
Yes.
See, they're objecting is the form of the question, like they're leading questions, but they're not. They do not imply the answer based on how the question is asked. So therefore, it's not a leading question. They're just yes, no questions. Yes, no questions are not always leading questions. They're just yes, no questions. We knew this was coming. We knew that Canoni was going to make, direct examination impossible for Karen Reed's team because she's a compromised bitch. She makes this Commonwealth look bad. She makes the judicial system look bad.
Your Honor, if it pleases the court, I have evidence to show that Kurt and Keanu performed sexually in a scissor position so they can dock and mash together their swollen micropeens.
Well, I think that puts us at what, 2 so far? Or no, is that the inaugural? That's the inaugural micropene. There we go.
Forget the power of technology and science, for so much has been forgotten, never to be relearned. Forget the promise of progress and understanding.
We're going to have to.
In the grim darkness.
Ma'am,
No.
Your Honor,
Yes.
thank you.
Hold
Back to
on.
my question.
Shit.
Was there any circumstance based on your review that if the tech stream event occurred at
I got to figure out how to get that off the screen.
38, that there was any circumstance that the lock event occurred before that trigger?
Oh, wait, here we go.
There was not.
I'll play it in a minute.
Did you create a PowerPoint for clarity's sake in March of 2025?
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
That's annoying.
No.
So the answer is no. The answer is
Following your presentation of the PowerPoint to us, at some point, did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough. Fair enough.
Fair
Did
enough.
that report, or did that PowerPoint, however you want to put it, markedly, was it any different than his January 2025 report?
Yes.
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025?
Yes.
Were those two things different?
sustained.
Were the conclusions, not his opinions, were his conclusions different?
Sustained.
Was there any difference in the two reports?
There was.
Tell me the difference.
Jesus.
In the
She's
first
going to make it
report,
a nightmare for them to do this.
Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original
Correct.
report. In the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Objection.
Sustained.
Did you seek to clarify Mr. Burgess's analysis?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
It's insane. They're just not going to let him ask any questions. All right, back to this.
Forget the power of technology and science, for so much has been forgotten, never to be relearned. Forget the promise of progress and understanding, for in the grim darkness of the far future, there is only war. There is no peace amongst the stars, only an eternity of carnage and slaughter, and the laughter of thirsting gods.
Which chaos god would you worship, and why is it obviously Slanesh?
Well, you know me. But I actually don't answer that as a Slaneshi. No, thank you. It's Papa Nurgle. He has the best gifts, and you know that. Let's see. What do we got?
Why is John Goodman on your thumbnail for today's video, Nick? He got buddies who died face down in the muck so that you and I can enjoy this family restaurant.
Yeah, I don't know why John Goodman is there, but he is. He is, and I'm happy about it. At this point, the defense should just call her out in front of the jury. Should call another mistrial. Start it all over.
May I?
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason, and what was the purpose for your PowerPoint presentation?
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
May I approach?
Yes.
If you wouldn't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it. What is that document?
This is a printout of the PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
Okay.
May I have that back from you for just a quick second?
208. Thank you.
It's not an insult to John Goodman. I see who he's talking about. One of the guys
Permission to
down to the
display the PowerPoint presentation?
Okay.
guy right below Alan Jackson's wiener in
So,
the
can you still
thumbnail.
see with the lights off sufficient to see what's on the screen and what's in front of you?
Yes.
Okay. Do you recognize what's on the screen?
Yes.
What is that?
That is the title page of the PowerPoint that I prepared.
And what is the?
I have a real
how
degree.
would you
I'm a fun guy. I'm a ton of fun.
describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With course permission, can we go to slide 2?
Yes.
Solomon says, are there ways to remove biased
Yes, you
judges
can
from a
just use
case?
PowerPoint. It's in evidence. You don't have.
Do you
to
think there
ask.
should be more
Thank
ways?
you,
What
Your
would you
Honor. Taking
suggest?
a look at this next slide.
Yes, there are.
is
Except
this?
usually you're
What are we
asking
looking
that judge
This
to
is a
remove
slide
himself.
from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, I guess, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with in Mr. Welcher's presentation that you disagree with? It's up on the.
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's. And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred 26 seconds after the end of the vehicle event as calculated.
No, I'm going to allow it.
The phone interaction happens how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So what
Did you, I'm sorry, Mr. DeSogra, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides, or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the time, the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162.2 ends at 12:31:43. And they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event. So I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording. Yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12:31:38.
Correct.
Okay. Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 12:32:09 lock.
Okay, let's go to the next slide, please. What does this slide show us?
So this here, what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window, which should make, we have a lot of numbers to go through here. And so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it. Let's go to the next slide, please. What does this slide show us?
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
Yes.
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all of the information comes from the Aperture reports collectively
Okay.
from Dr. Welcher and Mr. Burgess.
Can I
Mr.
comment on
Burgess
his hairdo?
make any
He looks like a
adjustments
vampire.
from his
I love it.
original report to his
Looks like he
subsequent
ran
report in
super
May of
fast through a
2021?
Vaseline
Yes.
sponge.
Let's go to slide 6, please. Tell me about this slide.
I feel like his hair looked
So
like
this is
mine
the
until he
first
sucked the
adjustment
soul
we're going
out
to
of
talk about.
a child.
And this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment. And we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered.
I don't know, Lilac. That wasn't
in
a
the infotainment.
negative
So the
criticism.
time we see
These
is
hairs awesome.
basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, you mean
Oh, hold
push
on.
computer, could it be the push button to turn the car on?
In this case, it's a button.
We're all
I refer
familiar
to
with how
key on
computers
because generally
turn on?
that event is considered
I don't
the
think
key
Shannon
on
Burgess is.
in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described?
It
CRC.
means that when we're
See why
trying
guy
to
says that he looks like him?
use the timestamps
I see what he's
that
saying. I just disagree.
were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually
Says a shiny
or
cheek.
likely turned on 3 seconds before that.
Do you know where the 3-second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Miss Reed's actual Lexus?
No,
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3-second delay? Or could that be different?
it could be different in their testing. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3-second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus, but without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5. So we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3. And then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices with regard to trying to create this gap for purposes of
The Iceman is DUI guy's
an
brother here,
opinion-
first
an
defense
opinion or an
witness.
analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7. What are we looking at here?
This is an excerpt from Mr. Burgess's original report. His page 28 and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3-second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from. And that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3-second delay, was that actually in his report?
This is the only point in the report it's mentioned.
I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3-second delay was noted in his report.
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
Why is
did
Wyrick
not.
welcome to
Sustained as to that.
paralegal?
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason
The black plate, I'll
he
get
did
your
not
super chat in a
apply
minute.
the 3-second correction?
It's
He did not.
appreciated. I just need time to answer
When
it.
you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
In your opinion, was it best practice to
Objection.
not account for that 3-second delay between the on switch and the data coming on?
Objection.
Sustained, ask it differently.
That was
What in your
super
opinion
leading.
would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if the 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the Aperture reports compared the vehicle to Mr. O'Keefe's phone.
Is there any additional adjustment that you believe should be made?
The Aperture reports lay out 2 methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point turn.
And where did you get that information from?
From the Aperture reports.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as 0.154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point you said was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist.
NBA dude says
both
body cam
in
footage for the
infotainment
win.
from Ms. Reed's Lexus and in
Okay.
Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43.
He also says Aaron
where
M
do we end
holds
up with,
1.
John's interaction
Okay.
window in those times.
What did you conclude in terms of finishing the work?
Sure, I did all of them.
Thanks for the $10.
And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
So on this slide, I just took the other end of the spectrum. There's a large range in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but
What do
actually
you mean sign conventions?
sign conventions, he doesn't show when he calculates the difference, whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a positive 5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. And the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it. And he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20. And when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes +6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welch's report?
Yes.
Let's go to slide 12. What are we looking at here? What is this table?
This is a table I made. We've talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, with, without key switch, phone calls, and 0.154 on one table. And I calculated John's interaction window for all valid combinations from the aperture reports.
Yeah, tide will roll. That's
Do
weird,
that.
isn't it?
The result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, the phone lock event always occurs after the end of event 1162-2.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No.
In his May 2025 report, did he undertake all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
You've already indicated that you received a second report, May of 2025, correct?
That's correct.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13. Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the 3-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up
That's the best.
that there's
No one
a
wants to do
range
math.
now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the 3-point turn data from the phone and the 3-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide.
That's a lot of
And so
conclusions.
just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support 1 point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the 3-point turn?
He opines in that aligning the 3-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess in his report indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
It's my opinion they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide 14, please. Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into 2 tables. So we're going to look at this, and then we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a continuation of the
second half? So think of these as a singular table. I just had to split them up. If we head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on.
Nice,
That's the
man.
main
This is a
difference
middle
between my
finger to
two tables.
Captain
Table
Stem.
one,
Go, Nick.
I'm not accounting for the
Anything?
3-second key on. In table two, I am.
When you
But-
say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as a singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15? This 14, let's move to 15. Now, this is
Same.
the continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay,
Just a continuation. Imagine in your mind is just row 16 to 30.
okay.
And it's the same thing, same format, except for now we're just adding in that key on adjustment because again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees. And one of them, it's 0, again, simultaneous. And there are no negative values with this adjustment.
Can we go to the next slide, 16, please?
Oh my gosh.
What are we looking at here?
This is the summary then of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the Aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros, they're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the text stream event?
Sustain.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the text stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, it's sustained and it's stricken.
What percentage is 3? Just do basic math for me. What is the percentage between 3 and 30?
Sustained.
Your Honor, may we approach
If I
him?
told you hypothetically,
What?
See you type out for a second.
He hasn't gotten to ask the question. Like I said, Canoni's going to make this near impossible. What isn't impossible, of course, is using super tips, supertip.gg/RL, and you can send in gems like this.
I've got to know, how in the world is this going to look upon official review? Does she think she is above inspection? It is so clearly openly corrupt and biased. And more importantly, will we at least see justice in her facing any sort of punishment? Or will she continue to act in party with the abuse of power from the state against innocent civilians?
Yeah, you're not going to see disciplinary action against Bev Canoni in this case. Not so far. If that's what you're looking for, adjust your thinking. You will not find it.
If this trial was on fire, let's just say I would have secured an alibi.
Oh my gosh. Okay, we have a couple super chats in here as well. The Black Blade says, would it be possible to utilize AI tech in a courtroom setting to assist attorneys in presenting evidence to jurors? That's coming. Court tech is always like at least a decade behind everybody else. It moves slow because of what's at stake. But yes, I mean, I remember when they started using the first, like computer renderings, 3D animations to simulate what happened during a gunfight, for example. I think was one of the first ones. And it showed how it was such basic 3D animation when I think about it now. Because I think it was back in the 90s. And, now they use these types of visual aids more often. But it was big news when it first came out. But of course, 3D animation had been out for a while and its potential was plainly apparent. It was really expensive to make, which is why it was a bar to most legal teams at the beginning. Now, of course, like you can just have ChatGPT render out anything. Or something like not ChatGPT necessarily. I think you have to use Sora or something.
Following your analysis of the totality of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
What is that What is that mechanism?
That would be the airbag control module,
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot of operational parameters about the vehicle. What I mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position, whether the brake is being pressed. It also records what the vehicle is doing, for example, speed or the engine RPM or the accelerations of it.
Does the TechStream data event indicate that there's a, and I'm talking about very specifically the TechStream data, does that indicate whether or not there's a collision in the car?
No.
Does the TechStream data event mean that if you find a TechStream data event or a trigger event, does that mean that the airbags are deployed?
No.
Does it mean that the vehicle impacted with something solid?
No.
Does it mean that the vehicle impacted with a pedestrian?
No.
You reviewed the raw TechStream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many TechStream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Sure.
I object to the whole line.
And I need to see what's up.
Oh my gosh. It's going to object to the whole thing. I'm just objecting to the case, Your Honor. Your Honor, I object to the defense. All of it. Mistral says, just tuned in. Is this the anti-Semite chat? I don't know if you want it to be, I guess. I haven't seen much anti-Semitism here. Or pro-Semitism. We're neutral in the issue, I guess. Oh my gosh. So anyway, back to the Black Blade AI video construction of a crime scene and a visual of what their evidence would infer. Right now, I don't think the use of AI would be admissible. You'd have to bring in an expert on AI to talk about its reliability, and I don't think anybody could credibly do that. That says, yeah, we've put this into the AI, and this is what it spit out. I mean, you'd have to show the parameters. Can you imagine the questioning? It'd be like, okay, what prompts did you use? Go through the entire prompting process. Explain how AI works. Oh my God, it would be a disaster.
Nick, do a whip it on stream and destroy your brain further, please.
Okay, I'll do it right now. There you go. That'd be great. So I'm working on something over here. This could be fun. Oh my gosh. AI is subject to programming parameters. Yes, it is. Oh, the Iceman says his DUI guy's brother here for the first defense witness. Yeah, a lot of people are. Well, some people are. I shouldn't say a lot. Some people are saying that this guy looks like Larry, DUI guy. By the way, slap that like button if you're enjoying the show so far. It's been kind of a quiet morning from me. But go ahead and, like I said, hit the like button. I'm just letting the testimony go. It's forensic testimony just gets mind-numbing on my side. This guy is here just to cast doubt and aspersions on the reports of Shannon Burgess, which is a good thing to do. Absolutely good start. It's a good thematic start as well because it goes into discrediting the prosecution's witnesses further. So we can see that's a strategy that Karen Reed's team is going to bring in, discrediting everybody. And their credibility was shredded one by one on the stand. Now they're going to go in and talk about just the work that they did being completely useless. But Canoni's making it very, very difficult.
Nick, you got ass fucked by Keanu and Keno Casino FTW.
Well, at least my prostate enjoyed it. Steven Alvarez says, we hate anything non-American here. Now it's judges. Is she a non-American judge? Let's see. Weiss Wyrick, welcome to Paralegal. I said that earlier. Scott Chrissy Jones says, happy Friday, one and all, except micropene people. Oh, we got that on the micropene counter. That puts us at 2 micropenes for the day. I'm about ready for a new joke. I mean, I like this one. Don't get me wrong. I'm just ready for something new, something fresh. Let's see. Boosh says detailed metadata prints for evidence. Steven Alvarez says, oh, yeah, we just read that one. We hate anything non-American here. Now it's judges. Thoughts on how close we are to a court oligarchy? Like the judges in the Bible? Like a triune set of judges who rule the country? I don't think we're anywhere near that. Eric July owns you. We're good. Reparations for my people owning his people in the past, I guess. It had to come sometime. Actually, I don't know that. I know my dad's side of the family, there's not really any slave owning blood, at least as far as in the United States. They were Polish immigrants and not too long ago. So, my grandfather may have been the first gen. I think he was first gen American. So there's no slave owning going on there. Who knows? Like back in Poland, I don't know that Poland had a strong history of slavery. Will you go on this little piggy tonight? Probably not. They usually don't invite me on. I mean, if they really wanted to, I guess I would, but depending on timing. Let's see. Shit. Wait, am I going on Zia's show today? Let's see.
Mr. Jackson, how much longer? I'm
today
just
Friday?
trying to figure out.
No, today's.
I'm wrapping it up.
Today is
It's
Friday.
not going to be long. A few more questions.
Yeah, I
I'm
should
not
be on.
curbing you in any way. We
Yes,
just,
today.
Understand. Respectfully, it won't be very much longer. You reviewed the tech stream data,
Whoops.
otherwise known as the triggers, for the entirety of Ms. Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
And last question, do any of the tech stream events or do any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time?
Objection.
ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
Okay.
That's all I have, Your Honor. Thank you.
Okay. Jurors, we're going to take the morning recess.
There we go.
Some things that
Morning break. Usually these are 20 minutes.
we'll have you come back at 12.
Steven says you still have your ABA license yet. I don't. No, I don't have an ABA license. American Bar Association is not a licensing agency. It's a
Can I see
professional
counsel at sidebar
organization.
to save us some time, please?
I'm licensed by the Minnesota Lawyers Registration Office, which is overseen by the Supreme Court of Minnesota. We do not have a state bar association. We don't use the American Bar Association. I'm licensed, but I am currently suspended due to a lack of following up with my continuing legal education, which I was supposed to report last year. However, due to personal issues, I just didn't keep up with it. So for now, I don't have, well, I have a suspended license, but we'll get it back eventually when I have time. I don't need it at the moment. I don't have any desire to have any clients or anything at present. So I've got other stuff to deal with first. Although, as stated, there is a proposed, I should say proposed, but nothing's been proposed, so it's kind of weird. There is a demand for me to explain my criminal charge situation, which I've done, and to talk about how I should discipline myself, or how the lawyer's professional responsibility office should proceed with disciplinary action or not. They literally did the Ayn Rand thing where it's like, you must participate in your own punishment. And so I said, you didn't really accuse me of anything, so I'm not going to accuse myself of anything. So we'll see how that goes. I thought they might try to come after it. They don't have a good legal basis for coming after my license at all. On that front, that may not stop them at all. They may recommend me for disciplinary action or something. We'll see. If they do, I'll, go fight it. It's like, your actions hurt clients. How? I don't have any. Well, your actions hurt prospective clients. How? Every time anybody calls, I say, no, I'm not taking any cases. I don't want to work. I don't want to do it. Leave me alone. Go call someone else. So that's not there. I didn't take any client money. I didn't mishandle funds. I didn't do anything to affect any clients. No clients have made any complaints because there weren't any. I was doing this. So we'll see. We'll see what they do. Mactavia says, did you see the news about the DOJ letter to the ABA? Nope. Boosh McFadden says, expert opinion, Bev hair real, Kurt micropene. That puts the counter at 3.
Just wait until April goes on the casino and spills everything, Nick.
Okay. I don't know what hasn't been spilled yet at this point. Guys, you know way too much about my life already. So knowing more isn't going to really, like, again, I would prefer people let it go just because, there's other people involved. I don't really care on my front. It doesn't bother me at all. People can talk about what I did or didn't do all day. And they do constantly. That being said, I really don't know what there would be to reveal or spill. I mean, most people believe a bunch of shit that isn't true. That's worse than anything that would come out. So, like, it'd be anything coming out would go backwards in things. It would look better, I guess. I don't know. Who knows?
Yo, Nick, I do not understand this whole Kino Casino thing. I checked it out once, and all I could see was some fat, Krang-looking motherfucker spewing hate and cheese doodles.
Some fat, Krang-looking motherfucker. That was funny. I like that. I don't get it. I mean, PvP and Andy are relatively entertaining people in general. I'm not the biggest fan for personal reasons, but so. It just means I don't really want to talk to them or go on their show, but I'm not trying to shut it down. Let's see.
I will not allow computer-rendered video in my courtroom if something need to be reenacted. We prefer Judd the Chud to cosplay as the victim.
You just know Judd the Chud is going to dress up like O'Keefe to impress his friends at dinner parties. What kind of wardrobe budget do you think Aperture has?
I don't know, man. Was that guy poorly dressed? I wasn't paying that much attention. He was just in a suit. He looked kind of professorly. I guess maybe that's what they're talking about. It didn't look like an expensive suit or anything. You should go on and give your side of the story. No. No, I have no desire to go on Kino Casino and be monetized by them. That's fine. Like I said, they can talk about me all they want. But it doesn't mean I want to go hang out with them. It sounds terrible. You bet there's a little to expose, Nick. The drugs, the kids. The kids are children. There's not really anything to expose there. And people's desire to see the children is a little bit weird. That being said, the drugs I've talked about extensively, rather openly. I don't know what people expect there to be that's different. My descriptions are pretty consistent with what's in the police report, I think. So, yeah, I don't know. I don't know what else people are expecting to find. If there was something else, I would expect it to be in the police report. Let's see. That being said, we'll see what happens. I don't know. Null says he's going to intervene in my criminal case, which tells me that he doesn't know anything about what he's actually talking about in that one. Permissive intervention in a criminal case usually only matters if there's an issue within the criminal case that would adversely bind another party. And so then they go in to exercise a right. But there isn't an adverse binding of Josh Moon or Kino Casino or Kiwi Farms or anybody else by the process by which the issues in my criminal case were resolved. I was charged with a crime. I pled guilty to the crime, to the elements of the crime that were expected. And that's it. There's no impact to anybody else. I wasn't in privity of contract with any of these other people. And the binding of me by the state doesn't in any way affect them. So there isn't an automatic intervention. Intervention in criminal cases is pretty rare in general. It's permissive by the court, and I don't see why the court would have any reason to allow intervention, especially in a closed case in which all the matters were resolved. There's so I can't foresee permissive intervention. That doesn't mean it won't happen. It's just during his temper tantrum, Josh says he's going to intervene. I can hear his voice cracking now. Coming over the hills. But again, Josh has acted like a toddler the entire time I've known him. When he doesn't get his way, you can hear it in his voice. He said it. He's talked like this on my show. He's talked like this on his own show. He becomes a shrieky, petulant child whose blocks have been taken, and they must be brought back and arranged appropriately before him. So I expect more shrieking and crying from him. But if he wins, that'd be interesting. We'll see. I said, whenever he talks about his legal theory, it's like, well, you just wrote down some words. Those don't really make any sense. Let's see. Josh super tip voice win. That's funny. That's a good idea. Probably do that. You just want to make sure there's no impropriety on the side of the police. We're looking out for you, buddy. I didn't say there was impropriety on the side of the police. I didn't claim it. It was never brought up in court. I said that, I challenged the bases that they used for their warrant request, but that has nothing to do with the search itself. So again, a bunch of people can go online and lie about something. It doesn't make it true. When they bring it to court, they can't just say, well, everybody knows that Nick said this. You'd have to produce the time where Nick said the thing. But they won't be able to, because I never said that. That was a game of telephone that gets played on the internet. Particularly on Kiwi Farms, which is insular and has awkward social skills. So they get wrapped up in their own confusions.
Welcher dressed up like O'Keefe in the videos of his accident reconstruction. Completely absurd and disrespectful, like something you'd see on The Simpsons or some shit.
It can be seen as disrespectful, but I also think, he's trying to reproduce the situation as much as possible. And that includes a long sleeve shirt of particular thickness that he would want to have a comparable shirt to see how it might, affect any impacts that happen to the body. So I don't see it as disrespectful, honestly. If you're trying to recreate what happened, you maybe trying to recreate what happened to the shirt or how the shirt might protect or not protect the body in a certain way.
Nick, how can you say that about Noah when you acted worse than Josh ever has with Keanu?
What? I acted worse than Josh ever has with Keanu? Okay. I yelled at someone who deserved to be yelled at. That's about the end of it. She deserved way worse than that. But hey, you can only do so much through a screen. I would have yelled at her the same in public or in person or whatever. She's terrible, and she's terrible to people that I care about. So I wasn't going to have an erudite discussion with her. She's also, it'd be like, trying to argue with a fucking board. But that's fine. Oh my gosh. I have got to figure out what's going on with my sleep. No one cares about Keanu here or anywhere. Yeah, I'm not really keen to talk about it. There's not much to say. I yelled at a dumb bitch and I'd do it again. And I'd yell at her dumb husband again too. I don't care. You guys don't know about Just Some Guy. Yep. That was a weird one. They're like, you only yell at women. I'm like, well, man, I can think of like 5 different debates where I've yelled and screamed at someone. That happened on my channel, and all of them were men, allegedly. So that's weird. I'm not sure where that one came from, but it just goes to show, like, you can tell, like, who knows stuff and who doesn't, who's been around watching and who hasn't. But I'm happy to yell at people when they're dumb. Get checked for sleep apnea. Well, I've been checked for sleep apnea. I didn't have it, but that was years ago. Who knows? Lord of the Ree says, Keno Simps are just ass mad, bitch made faggots who are upset you're not rotting in prison. Apparently wishing for anything but your death in prison counts as sweeping. Cope harder faggots. So there you go. Thanks, Lord of the Ree. Thanks for demonetizing the YouTube stream. Oh my gosh. Let's see. Okay. I'm putting Grok to work on a very important task. Is narcolepsy still a thing with you, Ricada Law? Well, yeah, it doesn't really go away. I don't think. Nick, would you be okay with one of your daughter's husbands taking a side chick? It doesn't really matter if I'd be okay with it, right? Like, they're adults, they make their own decisions. I mean, presumably, they're not now, but they will be. You know, like, again, not to sit and get into my personal drama at all, but I don't think it's the situation most people seem to think it is. And it definitely didn't come about the way that people think it came about. So that being said, you know, it's up to them, I guess. Are they okay with it or not? I don't know. I would hope that my children find the relationships they're looking for. That's the best way I can describe it. I don't necessarily know what those will be or what they'll look like. I know mine never looked like what I thought it would from the very start. I was surprised by my own relationship the whole time. In great ways, most of the time, and then in bad ways some of the times. I think that's how life goes. I think that's how relationships grow and develop, and, you know, you make good and bad choices in them. And then after those good and bad choices, you choose to go on or you don't. I don't think it's as complicated as people want it to be.
Do you think there could be AI lawyer? Listen and give objection in real time? Questions, arguments? Also, Kurt has a micro peen.
Yes, I think AI lawyering is coming. I mean, if you think about it, you can talk, like, you can vocally talk to AIs right now. I think you would just have to, you know, hit enter every now and then. So if you hooked up the AI to the court's dictation software or whatever, the court's dictation system, or even just had an ambient microphone, I guess, although I think you'd want clear inputs from who's speaking or whatever. But yeah, have the AI listen and give you real-time, real-time suggestions. I think that's coming. Steven says, God makes you pay for hedonism. Simple as pay toll, move on. Well, I don't know. I haven't paid the toll yet, I suppose. Because, people really, really are hung up on it. And it's like, well, I mean, I don't know what more people want. Like, the only thing now I have is time. So let's see. Man, that'd be funny. Estimating push-up capacity is impossible without data on age, weight, training, or self-reported ability. No reasonable conclusion can be drawn. Man, Grok cannot figure out if Null can do a push-up either, so I don't know. I'm gonna put this prompt into ChatGPT and see what it says. New chat. Okay. Lord of the Research, you're welcome, Nick. Oh, and Monograph has a micropene. Oh no, now we're up to 5 micropenes, and one of them's Monograph, which is gross. So that's an update in my my Monograph case. People ask a lot about the Monograph case, what the status is. Monograph, his prior lawyer, Schneider, has withdrawn from the case, and Monograph has retained the counsel of Matthew Harden. He is the lawyer who represents Kiwi Farms and Joshua Moon. I referred Matthew Harden on the recommendation of recommendation of a trusted friend a while back. Josh was looking for a lawyer, so I recommended Mr. Harden to him. I want to be very clear and upfront. Matthew Harden is doing his job, and I respect him as an attorney. I think he's a really good guy. So I'm not, like I don't know. It's always weird because just mentioning someone can cause like ripples where people do or say something, and I want to be very clear that I think he's a respectable guy, and I have no like ill will towards him. Schneider, I do. Schneider, I think's a retard. That being said, he's gone, so it doesn't matter anymore. And I think the case will proceed on a much more professional level with Harden than with Schneider. And I believe, like we just agreed to extend everything out quite a ways. So no, there won't be any updates on that for a while, probably, but maybe. The GM, you realize that I'm not paying Mark Randazza $350,000. Like, you understand that was a joke that he was making, right? Like, you get that. I would hope that you understand that, but maybe not. Mr. Smeg, Nick's opinion of Monty is based on Monty losing the same argument in a past case. I mean, literally how I was introduced to Montegraph was on a stream with Medicare, in which we were discussing him losing a defamation case in which someone called him a pedophile and he lost. Montegraph has over a decade-long history of being called a pedophile online, and has some confirmatory statements about some questionable activities as well. So I'm not quite sure why we're here. Talking about someone and their existing reputation within the community. The online community would be the community, I guess. Is not defamatory if there's a reputation that's established that I can rely on, which I have no reason to disbelieve that existing reputation. So, okay. Leon's Law. Monty called me and tried to complain about me to my boss, but the boss is me. I think that's how I the first time I talked to Monty too, was like he called me after the gym stream. And he's like, I don't know if he thought he was going to be talking to someone else or what, but. It doesn't really matter. But like I said, I guess there will probably be updates in that coming up at some point here. Other than that. And if people didn't catch it yesterday before I got some personally sad news, which took me out of the mood to stream after court was done. But I did do a late night stream and talked about this just a little bit yesterday. Aside from that, before that happened, I did get an update on the body cam footage. It's public, so there's nothing for me to. There's nothing that I'm disclosing here that's not out there. The county attorney has reviewed the situation, and they have decided to file a motion to reclassify. I think there were two body cam videos that were uploaded into the Minnesota evidence system, but were not ever offered or accepted by the court. We did not end up needing to use them. So the county attorney has petitioned the court to reclassify those as not evidence, because it seems that may have been misclassified. And in doing so, they will maintain their private status. Body cam footage is covered by a specific statute. It's Minnesota statute 13.825. And if you want to go read up on it, you can. It remains private outside of various exceptions. It does not meet any of the exceptions currently. If it had been offered and accepted as evidence at a hearing or at trial, that would be different. That would change it to a public status, because evidence that is offered and accepted at trial is up for public review, as are any of the other, any of the elements of the trial, unless the file is sealed. The file hasn't been sealed, and there's no reason that I can think of to seal it or anything like that. It's a pretty straightforward criminal trial or criminal case. And however, as the body cams were not ever offered, nor were they accepted by the court, the county attorney has determined that, in their legal opinion, they should not be released, and has moved to reclassify them to make sure that that won't happen. Josh says he's going to oppose that or whatever, or sue the county separately. I'm not sure which one he plans to do. He's not party to that cause of action currently, or that case. So he doesn't really have any say in it. He would have to get permission from the court to even file something, I believe. That being said, he may do so, or he may try to. Spectre says, I didn't think Josh had standing to intervene. I don't either. But you can get, permissive intervention is there. He could request it. There's a rule about it. I don't think he fits the rule. I'm just going off of what he said. As I stated earlier, I think Josh sometimes gets ahead of himself on his knowledge of things. He'll read up on something, and he's a quick study. Josh is not a stupid guy by any stretch. He has, I think he's very intelligent, and I think he learns really fast. And I think he spends a lot of time looking into things. He's got enough of the tism to do that. But I think he gets ahead of himself sometimes, and it comes through in his language when he talks about subjects that he doesn't know very well, but he wants to. But that's okay. Like I said, we'll, the system will play out, or the situation will play out through the system. one way or another. I think it's funny that he's having a fit over it already. I'm going to sue. I'm going to sue. Like, okay. But I mean, just do it instead of whining about it.
Nick, did your dad have a turn on April as payment for sleeping at their house?
That's disgusting.
I'm not the pedo for the disgusting of IE for Aaron's daughter likeness. Nerds, it is Monty. It is always Monty. Monty.
Monty, is that you? Does Melton even know who you are? That's very weird. I don't know where that came from. Oh, I never answered Boosh. Is Bev's hair real? I think so. I hate it enough that it's probably real.
Yo, my nicker. Speaking of micropeens, talking about Monty, I remember the last stream of Legal Microsets. I watched Microset said you antagonizing Monty on stream is why he got pissed at you.
My nigga Microset then said that getting dragged into a lawsuit was too much. I was sitting like, bitch, I watched that stream. You did say shit at the time and we're having fun.
My Nika then, like a true micropeen, he then said he wouldn't read super chats on topics about things he didn't like. I was like, fuck this fag, I'm out. Dropped his crossed-eyed ass after that.
Wait. Mindset said that Monty is the reason that he didn't like me anymore. What? Why? Was Mindset around on that? I thought it was just Megan Fox and Sean. Monty put pressure on Sean. Sean's like, I don't want to be fighting the state bar, and I don't want to be sued. And so he pulled the bitch up and he apologized. He apologized to Monty for what he said or whatever, which is fine. Like, he asked me about it and I was like, go ahead, like, take care of yourself. What are you talking about? Why would you worry? Like, why would you worry about me on this one for what I said? You take care of your own thing for what you said. I didn't have any ill will towards that. That was the expected outcome. He means Sean. You just want the Kurt AI voice again? I do too. I have plans for it. Angel with 20 gifted memberships. Holy crap. Thank you. That is awesome. Hugely appreciated. Damn. Everybody make sure and thank Angel if you get one of those gifted memberships. Very, very cool. The gifted memberships, it actually gifts you in, I believe, at the lawyer level. Like, so it's not the low tier paralegal gift. It's it's at the lawyer set. It's the lawyer level, whatever it is. I'm trying to figure out how to do members only streams on Rumble. And I put a question into them, but I didn't get one. Or I didn't get an answer yet. So I'm trying to figure that out.
Get me out of here. Come and see me. I'll heat your dick up with shit. Also, Kurt has a penis in proportion with a Foster's beer can. It hurt.
What? Oh my gosh. What was that? Get you out of the way. Ronnie, are you in danger? I think he means Florida prison. How's long to make member only streams in the cold? Spectre says you can't right now. It looks like if you have premium, you count as being a member. The crazy thing is, so I used Rumble Studio to create a local stream, a Rumble stream, and a YouTube stream. And the only one I was able to turn to members only was YouTube through Rumble Studio. That's the only one I was able to get to switch to the members only production. So it was very, very frustrating. I got to figure out how to change that, I guess. I have some ideas. I think I know how to do it on StreamYard, except for, again, getting members only on Rumble. So maybe I got to talk to Viva about it. I think he does a lot of that stuff. Jesus, these breaks. This is a long one, man. That's what she said. What, it's 20 minutes, I think. Sangland says, Nick, if you have the time at some point, love to get your thoughts on this guy. Oh, wait, that was from a while back. Ammon Hillman. I haven't watched his video yet. Do you think the defense is going to continue? This is from the Iceman. Continue to be leading, etc., at points in order to get State and Bev to call them on it, sort of like playing to the ref like a coach would advise his players. What do you think? Also, love you, Nick. Screw the haters, by the way, doing locals because screw YouTube. Holy shit. Angel sent 20 more memberships. Damn, girl. Thank you so much. Holy crap. That is very much appreciated. I mean, yes, the defense team knows what they're up against with Bev, like we can assume. So will they be playing to the ref? Yes. But it's going to be really, really frustrating for them. You can see Hank's gone to sidebar with her, what, 3 times? Or not Hank, Alan Jackson has gone to sidebar with her 3 times now because of how she's handling these objections. And how often they're coming. And on lines of questioning that he needs to be able to engage. So it's just, it gets silly at some point, and it becomes apparent that there's some biases that are taking place. Let's see. Inspector, I'll message you. Lord of the Recess legal mindset banned me from all his chats for pushing back on a guest that said Cody deserved the death threats he got for making an obvious joke. Bitch made retards. Oh, is that when Cody said I'm not with Pippa? And he put up a picture of his girlfriend, but he blanked her face out. That was, and they're like, you could have gotten her killed. It's like, no, I don't think so. That wasn't her. That's weird. Where is? Don't you hate when you have like a window somewhere and you just cannot find it? I don't want that. Legal mindset blocked all criticism. I'm blocked too. Look, I don't much care about legal mindset at all. His like his random like heel turn on me was weird. I still don't know why it happened. I have theories. I'm sorry about him, like, but what's done is done. I have no desire to interact. Like, I don't care. I just, when people tell me that they don't want to hang out with me anymore, however they do it, I'm fine with that. Like, okay, I don't want to hang out with you either then. Meanie. Get away from me. It's my slide. No, you can't be on my merry-go-round. It's mine. You make it unmerry. But all I have to do is tell me, like, and I won't bother them anymore. I don't have any desire to do that. Lord of the Reed, joke's on you, Nick. Legal mindset is glad he has a lazy eye because he can goon over ladyboys in 2 different towns at the same time. Why is he in Thailand? I always thought he was in Korea. That's what he always said. So did he migrate? Nick, how much more in legal fees before you start OnlyFans? I don't know. Would you subscribe? I'll do it. I'll just recreate all of Kurt's cooking videos, but in the nude. Yeah, mindset is in Thailand. Barnes use that to insinuate mindset is a pedo. I don't think his mere presence in Thailand insinuates that. But I do think his how to be a sex tourist in which would be how to be like an American Chad in the East website and / business or whatever that he was running. That's more sus. You know, I don't know. Like when I hung out with Mindset, he didn't seem like a pedophile, so I'm not going to call him one. I know people have their suspicions about why he moved to the East or whatever. I don't know anything about him. They said they don't care that much. I thought we always had good, discussions or whatever. But when people tell me like I don't want to hang out with you, again, however they do it, I'm happy to oblige. I don't mind. Thailand implies ladyboy hookers. I mean, again, I don't have any information about that. I have evidence to suggest that, Legal Mindset enjoys the company of women. I have evidence of that. I personal knowledge of him enjoying the company. Like, I do not know. I don't know if they had sexual intercourse. I wasn't there for that part, but he seemed to be enjoying the company of a lady and left the the bar we were at with said lady. And then no one saw him till the next day, which, I mean, good on him. I don't care. But I never saw him do that with a boy or a man. So I don't have any evidence to suggest that at all. Anyway, I don't know. It was strange. But if people like someone said he saw my spiral and bailed, that's fine. What do you do about it, right? His terminology of smashing it with the ladies is just off-putting. Well, he exists in this world. He's friends with Fresh and Fit. And so he was in that I think that trend is kind of fading out, but that sort of alpha beta male empowerment space that existed popularly online for a couple years. And then guys went back to work and they're like, oh, we got to go to work now. I forgot. We can't do this online stuff where we're super alpha chads or whatever, because at the end of the day, most of us get up and go to work. Is what other guys, like, not me, but that's what I think a lot of men were saying. Like they had this idea. There was this idea online that they were going to make a male empowerment movement. They forgot that men typically don't have time for stuff like that for extended periods of time because they got to go to work. They got to build a bridge or whatever. Because we saw what happens when women build bridges, they break. It's so funny. I'm sure there's like at least 5 or 6 bridges out there that women have built that haven't broken. But the ones that do break, it's like, well, who's the lead engine? Of course. Name is Takesha. Papa Slapnuts is great analysis of the Karen Reed trial, Nick. What do you want? There's not a ton going on right now. We're on break. the defense's opening strategy, I've already talked about, or their continuing strategy is to continue casting doubt on the witnesses of the state. Right now, they've brought on a witness whose entire job was to analyze the reports of Aperture, of Shannon Burgess, both of his reports, and to just jump on him. And that's what they're doing. Other than that, they haven't like elicited much testimony. They're going after his time adjustments right now. There's not much to say about it. We talked about it earlier, though, at the beginning of the break. You should have been here.
All right, Mr. Brennan. And Mr. DeSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on and the fans. It's
Hey,
a
what's
little
up,
stuffy
Ty?
in here, so if you just speak directly into the microphone.
Yeah,
that would be
Stephen,
great.
lead attorney has always been great. Okay, so Hank's on cross. I'll be right back.
Good morning, sir. Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022?
Is that, I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022 or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision.
That's text stream data can be triggered by a number of different things other than a collision. Isn't that true?
Correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right. Mm-hmm. Right. So there's other things that will trigger text stream data.
Correct.
Like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30% in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you.
I'm allowing this.
I'm asking you, if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers in, there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, is that, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium
Holy
to
crap,
high
I'm
is
back.
what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? You know.
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the text stream data. That's the EDR. data, correct?
Yes.
You would not expect, it would be
Yes.
abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal. to register
I'll
that
allow
data into the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the
You're
case.
saying it would meet that,
Would not.
would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text stream, correct?
Data.
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously, we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's
The
no
data
way to
only
know
tells us
beyond
about the
that from
data.
the data.
All of your equations and pluses and minuses and graphs you're talking about deal
All your
with
pluses, your
10
minuses.
second text stream data that was captured, correct?
They deal with event 1162.2
This data is
and
like
the 10 seconds it's comprised of. Actually, they
four
really just deal with
witnesses
the end
about
of the
pluses
event.
and the minuses.
That's what everything in the Aperture reports reference.
Fair enough.
You
But
and
it
your
doesn't
pluses
deal
and
with
minuses.
anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, it captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No.
You have no idea, right?
I don't.
Okay. I want to just ask you some questions about your background and then leading into this case, if I could. You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month. Correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction. It was data analysis.
Okay. you continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Imagine
Yes.
unironically doing your
You
continuing education.
focus as part of your specialty on EDRs, don't you?
That's correct.
Event data recorders.
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it. But oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars
Any seminars?
on variances relative to mobile forensics?
There aren't any.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of reports from Dr. Judd Welcher.
Didn't Shannon
Yes,
Burgess
yes.
basically say that
And
the variance
Mr.
thing
Shannon
was
Burgess,
Correct.
in reviewing those
something
reports,
he created?
you've
Like there's,
offered your opinions and analysis.
he's the only guy?
Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
He didn't
Did you
need
ever
to.
do any actual testing in this case?
No.
He didn't
So
testify
your
that he
role
did.
is to look at other people's work and offer opinions and criticisms, basically.
Yes.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case,
You what?
Mr. Jackson, my client.
Did you ever speak to me?
No.
Why? Why would he?
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, You were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about? You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint.
Yes.
And then you received information from Mr. Burgess.
Yes.
And then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
They had a copy of your PowerPoint on May 25th.
I would think so.
Don't be shy.
No, I'm pretty sure it was the 25th.
Don't be shy. Wow. Calm down, Hank.
You
guys are winning today.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
Yeah. No reason for you to hold on to it for a couple of days.
No, I think it was the 25th.
Do you know what was provided to the Commonwealth that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information in it, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked?
My clients, Mr. Jackson.
He said, please have this on the 25th.
We had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so and then provided it.
How did the date of the 25th come about? Why the 25th was the date provided?
That's when he requested it. I think it was a Sunday, actually.
When you first got involved in this case, it was last fall?
Correct.
And at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
There was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules and try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. And whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms. Reed's Lexis materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained.
It's
It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits. And Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip off, no further study of those chips, other than to ensure the amount of memory was sufficient.
Yes, I already noticed the whole thing was fucking
It's
stupid.
not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
Mr. Burgess proposed protocol labeled, "We attempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components."
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it for action, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on, ignition off information.
Yes.
And infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. Pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry, so can you restate it, the whole question? Yeah. Yeah.
You said you have some experience in accident reconstructions.
Yes.
Don't you want all the data available? More data the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, the data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions, in some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and time which will match with the text stream data, correct?
Yes, it does.
Because you know text stream data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
And this had a running time instead. Like
That's
a stopwatch.
correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there, if someone knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Sustained. I'll strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes.
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
He actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips. And it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas. And then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but in your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight?
Objection. Sustained. You can ask it differently.
Did it ever dawn on you, as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
According to Aiden Kearney,
At the time, I thought it was a possibility.
one of the jurors'
If you
mouths that
reference
Hank Brennan was
the
a
initial
dick
work,
weasel.
a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there. There could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, when you were watching Mr. Burgess work as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you what he was doing.
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
When you are considering all your equations, did you consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes? Are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
No, I don't study. I don't do that.
Now, we agree, or you agree, that there are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically this Lexus, I don't know if we can make the statement that it's common or not, because again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of possibilities.
I understand your point.
Yeah.
If you see as an analyst a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay. If we could put up Mr. DeSorga's new PowerPoint, 52525. You've made a modification to your PowerPoint.
Yes.
You've made an amendment to your PowerPoint.
Yes.
So there was something that happened, you received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible. So I included all the data.
And you would expect that from any expert, wouldn't you? If they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint.
So apparently everybody
provided,
knows
wouldn't
about
it?
these clock variances
to
and
allow that.
no one did it.
I don't know if I would tell other experts what their best practices are. I would say generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
Sustain.
Hank is such an asshole. It's kind of funny.
Okay.
I would like him if this didn't matter.
Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I did not.
reports. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation. So I'm taking them at face value, but as being correct.
It's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on
This guy's kept his
154
cool
on Mr. O'Keefe's phone, stamp
better than
154
Welcher did, for sure.
as the end
If that keeps
of the
up.
event as opposed to the beginning of the 3-point
He's only been
turn,
up there a couple hours,
11:62
not 3 days.
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the 3-point turn.
Not on this slide, on a later slide, but yes.
Okay. And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing two different devices, right?
Yes.
Okay. Turn to the next page, please. You point out 2 times for the
When you're
jury,
comparing
the
two
Lexus
different
event,
devices
11:62
grabbing the same
and
GPS data, though?
12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
It's that time is based on 2 things: the clock in the infotainment unit and the cumulative key on timer in the text stream data. So it's a combination of 2 values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 123209 isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 123209.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are 2 different devices, 2 different clocks that will have a variance.
Yes.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right?
What?
The trigger event. That's not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, I'm not the only instructor. Collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition and subtraction or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger one.
Absolutely. And that's why I didn't change the convention here. I used their convention,
So you're
apertures.
not suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No.
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event?
No.
So you're not offering criticism on that. So just so I understand.
Not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis. So I wasn't changing in the middle, trying, you know what I mean, trying to obfuscate what I'm saying.
I appreciate that. I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Could you give me that?
Yeah, you were
A little
suggesting
different.
those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds to the time of the trigger because you're starting at the end from both devices.
Objection.
I'm going to allow it if you can answer it in that form.
It's going to depend on
If he can do it, I'll
if
allow
you're
it.
doing an
Wait,
alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, you're basing it off the end of the event, the end, not the trigger, the end, comparing it comparatively to the end of a different device. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
Did anybody say you would add 5 seconds for the heck of it?
You see 12:32:09 minus 12:31:43, the middle line, equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly. Before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report, isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in that.
Did you see when you reviewed reports that Dr. Welcher uses this exact number plus 26 seconds in his report?
I got the number from the PowerPoint.
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just copied straight from that.
And you've labeled this John's interaction window.
I did.
Okay. Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough. Fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate the point you're trying to help us with. Like that a little forward. So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data? Objection.
I want to see you at sidebar.
Hank's doing what he's supposed to do, right? Like, what do you even do? You didn't observe anything. You didn't see this car. You didn't test anything. What the hell is your purpose? But he already said what his purpose was. His purpose was to come in and review the work of Shannon Burgess and to see if it was worth the paper that it was printed on. His opinion is that there are problems with Shannon Burgess's analysis, and he noticed it right away with the mistake of the gigabyte to gigabit, megabyte to megabit mistake that he made, and then he proceeded to go from there. So his job was to come in and offer a report that, or offer an opinion that Burgess's report was trash, and that's what he's done. Hank is trying to confuse things. It should have been objected to and sustained by Bev by, going down this line of questioning that he didn't, observe the car or anything like that. I think the questions about clock variance and the triggering events, the stuff that this guy is specialized in and testifying on, I think they're all fine. But the implication that he should have bought another car or that he should have observed the original car, neither of which he could do, should not have been allowed and shouldn't be. It's outside the scope of his expertise, outside the scope of his opinion, and implying to the jury that he should have done this, that it should have been within the scope of his opinion, or that he should have done these things that are outside the scope of his opinion is wrong. Like, and that's what Hank Brennan is trying to do here with that. So
The evidence will show that legal mindset moved to the Orient because he has a micro peen and wants it to seem like a slightly under average peen by comparison.
there you go. That's the evidence will show.
Hey, all you chat tars, smash that like button like Kurt smashes pizza casserole. Oh, Kurt has a micropeen. Share the stream too.
That's right. Share the stream, share the peen. That puts us at 8 micropeens for the day. I'm not expecting a 69 micropeen day ever again. If we ever get there, it'll be hilarious.
Look here, Nicker, peen, micropeen. Knickers like Kurt have the micropeen.
What? That's 9. Okay.
Why is the state being giant micropeen Kurt cunts? Faggots.
I'm so surprised that, the copious use of various slurs that happens in the AI voice. They don't, all the streams have been saying monetized, which is crazy.
Where did that come from? Wait, I made explicit comments about a minor child. And that is why I'm called a pedo, right? And if so, you still decided to be the guest of honor. Low.
Yeah, a comedian making jokes that are explicit about a minor child. I don't really give a shit. I don't know why people are pretending all of a sudden to make like such a big deal out of it. They're like, oh my gosh, let's kvetch. Hey, making jokes about children. Comedy can't do that. Comedy can't have jokes about children. When? Why? The current comedian I like is Anthony Jeselnik. I think Anthony is his name. And his joke is that he's at the bar. He's like, I'm at the bar and I see my favorite porn star sitting at the end of the bar. He said, I can't believe it. She's right there. And he says, bartender, she can't be in here. That girl's 13. I mean, that's a pedophilic joke. It's a funny joke though. It's hilarious. It's like, oh wait, he can't. That guy obviously is attracted to children now because he said that joke, right? Like that's the logic that is out there right now. People are like, oh, well, if a comedian says a joke that I don't like, they're obviously attracted to children. Okay. But hey, you know me. I'm all for the censorship of comedy. But that Jeselnik guy is really fucking funny. I like him a lot. You just got kicked out so your app could update? Well, don't worry. You're back now. Everything's fine, Lady Tammy. Project Calm says, are we near an objection for burden shifting? Why is it the defense's job to properly acquire initial data and investigation and find data initially? Well, it isn't. It could be beneficial to them to do so, though. Real Ron says, Jeselnik is one of the most overrated comedians that are alive currently. That's fine. I see him on short videos, and it's one joke at a time, and that's great. His whole sets might be terrible. I don't know.
So jurors, we're going to release you for the luncheon break.
Released for the luncheon break.
A nice full hour luncheon break. So we'll see you back here in an hour.
The full hour.
Rest of the jury.
Well, hey, while they do that, I'm going to go to the bathroom. I'll be right back just in case there's some arguments. And then we'll keep going.
Sir, follow me, please.
All right, sorry about that. We are on lunch for an hour here in here at the Karen Reed trial. So we'll be back, or they'll be back in court around 1 p.m. Eastern time. Wait, no. Central time. They take late lunches in this courthouse. Angel says, does anyone know if YouTube takes 40% of memberships too? It might be, I don't know if they do. It's not 40%. If anything, it's 30. I'm not sure. So anyway, oh my gosh. So what do you guys want to do? We've got some time. I guess we could go back. I didn't watch the very beginning of the day. So I could go back and watch. There was a motion to. Oh, wait, no, that was yesterday, right? Was it today? It was today. There's the motion for a directed verdict. They lost. They have to make the move for it. It's just part of your job because you can. It creates an appeal point if nothing else. Dapple Darling, thanks for the donation. The message was retracted. Stephen Alvarez says, Dice, Little Boy Blue. Hey, he needed the money. Okay, that's kind of funny. Neurodivergent one says they should gift the memos from the browser, not the app. Yes, always do that in general. Although I think that's about to go away. I think the store, the app fees are going away because Apple lost that lawsuit. All right. So, okay, do you guys want to see something really weird? Just for a second. I tried this earlier. I know the answer to this roughly. But something weird happened. So I typed in this question. Has Joshua Moon ever made controversial comments about children suffering or Shota illustrated pornography? And it started to type up the answer. And then it stopped and said error while searching. So I said, retry that. Error while searching. Retry that. So let's try it in real time. Retry that. Now watch this. Yes, there's documented evidence that Josh Moon, known online as Null, has made... Where'd it go? That's weird, right? That's a very strange thing to happen. Nick, do it again, but get ready to print screen as it completes. Well, I mean, the video's up. The answer is there. So it's on the stream. But that's real fucking strange. I mean, it wrote several paragraphs before that happened. That's happened every single time. So anyway, I was just like, because I was trying to find the old comments that he made about him. They were from a long time ago. I don't know if he's still into it. Chugi Show Live says, I knew you were a piece of shit, but a father of 5 with daughters thinking pedo jokes are funny is disgusting. You can join the maps on the wall. So if I don't have daughters, I can think pedo jokes are funny. You can join the maps on the wall. Okay. Guys, let me introduce you to the Chugi Show Live. You should go check out the Chugi Show Live YouTube channel. Make sure you like and subscribe. It's always good to help the disabled with their endeavors, and the Chugi Show is no exception. I mean, don't get me wrong, Chugi Show is exceptional. And her see-through backpack and shorts overalls probably are indicative of just how exceptional she is. Oh, Spectre. There you go. Sweeping up for Josh. Such a silly thing to do. As Nick is being walked to the squad car, he tells an officer, I hope you catch gonorrhea and die, based. Yes, I did that. That was funny. I was in a bad mood, okay? Leave me alone. Okay, let's go back to this. Let's go back to this morning at the beginning part that I missed. Let me see, duplicate this tab. She must have gone immediately to sidebar. Okay, here we go. Yes, we were at lunch. Remember when Nick would rant against cuties until Dax, said he liked it. Nick is a fickle fig. No, my position on cuties is always the same. It does not meet the legal definition of child pornography. No, just because the state, that one sheriff in the Texas county or whatever was made an arrest warrant or something, or attempted to get an arrest warrant against the creators of cuties or whatever. They lost that criminal case. I also said, I thought it was disgusting. And I was really worried about what they did with the, audition footage. I think that was probably something that has been mishandled, and I don't trust anybody involved in that. I've heard what the writer and director say they were trying to do with the show, to use the the grotesque nature of people's attraction to children as indicative of why this is a bad movement and the sexualization of children is bad. That's what they claimed. I get it. Like, I'd never watched the movie, by the way, because I don't need to watch the movie to know that it's not my thing. But I get the premise of it. My criticism was, well, there are different ways that you could do that without such sexualization. Different wider camera shots, for example. The not focusing so much on the sexual parts of children was the way that I would suggest doing that. But who am I? Just a humble internet merchant. But my entire, from the legal aspect, it just never met the definition of child pornography. And so I was trying to tell people, like, not to get their hopes up on some sort of prosecution for it or banning or whatever. It just wasn't going to meet up to the standards that people or that would allow that to happen. But that's all. I mean, that was my opinion. Dick and Vito's opinion on it was funny because, like, one, because of how catastrophic it was, but two, because they've never watched it. And a lot of people who call the Dick and Vito, like, pedophiles for it have watched the movie. Dick and Vito never saw it at all. Well, at least Vito claims he never saw it. I don't know if I believe him anymore. I'm mostly kidding. I don't have any reason to disbelieve him other than him being Vito. That being said, people lost their goddamn minds over it, which has also been hilarious. Like, don't get me wrong. I don't know what do you do about it? Maybe don't lean in so hard next time, or pick a different subject to lean in on, like cribbage or something. You know what we're not going to lean on? Pedophilia. All right. Doesn't seem like a good plan. Law Nerd says, good morning, Nick. I appreciate you covering this trial. # stop requesting Nick's body cam lowlives. Well, I mean, if they make the request through the proper channels and they, the expected outcome under the statutes is that the answer would be no. And if there's some exception to the statutes or something that I've missed, I would have missed it, obviously. I don't see it. But if there is, we'll find out. The courts will handle it. You said Vito was a pedophile for liking cuties. Yes, I believed that he watched it after he did he talked like with Mr. Girl about it or whatever. But then I talked to him in person. And I asked him, I was like, so you really like this or what? Like, you really watched the movie? He's like, no, I leaned into the joke. And I was like, oh, well, that was, probably not a good idea. And I've said that since. But yeah, at first, the way he talked about it with Mr. Girl, I was like, bro, gross.
Nick, I've been watching since Vic. I've invested hundreds of hours joining in on the depots and trials. I've donated, and I donate to no one, LOL. But this whole situation pissed me off because people forget that we are all fallible human beings who make mistakes and try to grow from them. We all need grace and we all need people in our corner when we fall. The problem is they think they're the heroes of their own stories. They aren't. And when they hit their bottom moment, they will want the very grace they didn't give you. Love you, Nick. Praying for you always, brother.
Hey, man, thanks. I appreciate it. When people ask me what they could do for me during all this, I just said, they'd say, I'm praying for you. And I was like, that's it. That's what you can do for me. Cause it felt like being in a whirlpool, whatever you want to, either one, they both work. And it was like, I don't even know what I need. I don't know what would help. So just thoughts and prayers or whatever. while you're at the In-N-Out Burger. What is this? Oh, okay. That's a good. Sorry, got a message. All right, let's go back to this. This is the beginning of the day. I didn't get to watch this, so here we are. I hate when YouTube does this. There we go.
So I'll hear you whenever you're ready, Mr. Jackson.
I won't.
Sure.
For what it's worth, I like Jackson.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds.
You know, this is a pro forma motion in a criminal trial. It's always made when the state rests. As I said earlier, one, it creates an appeal point if you think it's improperly denied, and it automatically kind of puts your foot in the door for the appeal, even though you're probably not going to get it on appeal. That being said, it creates an appeal point automatically. But two, if you win, you win. Like if you at least, or you can win on specific, on specific charges. Kyle Rittenhouse won on one of his gun charges because of their motion for directed verdict, because the state had failed to introduce the gun as the gun that Kyle Rittenhouse allegedly was in possession of. So the state got rid of one of his charges for that. And that was a good move. That was a good move by them to do that. So these are hard because you're going to lose. You're going to make and they're going to make a good argument for it. Hey, they missed this element, but Judge Cannoni's not going to, there was no way she was going to let him have it. And in a murder case, I mean, unless they really screw up, they're just not going to do it.
Seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date.
So this is an interesting argument because it seems pretty clear that the last witness, they had a whole argument about this, but that the last witness, the accident reconstructionist, had said that the injuries sustained by John O'Keefe were consistent with being struck by a car, a Lexus SUV, if you will, and that the damage done specifically to Karen Reed's SUV were consistent with a collision with a body. Now, I may disagree with those conclusions, and you may disagree with those all you want, but that is the admitted testimony of an expert witness and as part of their expert opinion. So that said, though there's no testimony that SUV was driven by Karen Reed at the time and struck John O'Keefe, I think I don't want to say dishonest. I think it's a stretch to say that there is not sufficient evidence in the record for that element to have occurred. But we need to take a pause for a second because we have the #1 tug simp with a very nice super tip. Thank you. Let's see what it says.
So fuck YouTube. Kurt has a micropene.
Kurt has a micropane that Vito would love to play with.
Free me. Thanks for covering my trial, Nick. Yes, I heard Kurt has a micropene.
I love Kurt's micropene. I want it. I need it.
I'll allow it. Kurt does have a micropene.
You know what? That is, first of all, $50. Thank you so much for that. I think that's 5 micropenes right there, because that's a full on, individual. Each one of those individually would have still been higher than a standard, a normal, a mere peasant's super tip. So we're gonna give credit for all 5 of those. I have no problem doing that. Micropene counter is up to 15. Thank you so much. Cooking the books. Don't tell my probation officer.
Nick, I love you. That being said, please lay off Kurt. He has apologized for his behavior at the Superdome. He stated it was an all-you-can-rate buffet, and you know his fat ass can't resist a buffet.
Oh my God. The Katrina Superdome? How old is Kurt? How old is attorney Kurt Mueller? It says he's 58. This got to be. He's 56? That's a different Kurt Mueller here. Who the So, May 16th, 2022, there's an article, Uncivil Law breaks down Johnny Depp and Amber Heard trial. For the Lone Star plate, my guest today is Uncivil Law, Kurt Mueller, age 58, and Austin-based. So that would put him at 60 now. Austin-based lawyer who has a YouTube channel called Uncivil Law. That can't be right. There's no way. No way he's that old. I thought I was older than Kurt. I still think I'm old. I still think I'm older than Kurt. I thought he's in his 30s, late 30s, maybe early 40s. Spoxbro says looks around 40 to me. Yeah, me too. He looks hot for 59. Hey, now I'm 60. There's nothing wrong with being 60. I just don't think Kurt's 60. That's got to be incorrect. Hold on. I guess I just asked Grok, right? Like, how old is Kurt? How old is Kurt Mueller? Okay, Uncivil Law. Show your work. Kurt Mueller was 58 years old on May 15th. We can estimate his birth year as 1967. I mean, the best reference is that this article's brand new. Lone Star plate dated May 15th, 2025. It says he's 58. I did not think. Why did that say 2022? Okay. It says 2025 on here. That seems more right, but still 58. That doesn't sound right. I just can't. I'm not putting that on him. Have you asked ChatGPT if Kurt has a micropene? I'm such a child. Okay, well, let's see. Okay, but does he have a micropene? There is no credible publicly available information or evidence to confirm or refute the claims about Kurt Mueller. Nothing to refute it. Having a micropenis. The term micropene appears in a single X post from May 28th, where a user, Pop Culture 72632, big shout out to Pop Culture, mentions being distracted from this alleged trait by a visual aid Kurt provided. However, this is an unverified anecdotal claim from a social media user, not a factual or medical assessment. And no other sources, web news or otherwise, substantiate this. I don't know. I think there's some medical context. A micropenis is a clinical condition where a penis measures at least 2.5 standard deviations below the average length for an age group, typically less than 4 centimeters flaccid. Oh my God. Or 7.5 centimeters erect in adults, affecting about 0.14% of the population due to hormonal or genetic factors. No such diagnosis or related discussions about Kurt Mueller exist in any relatable public record. Have you heard of super tips, though? Okay. Okay, that's enough. That's enough childish behavior. We got to get serious around here. What are you even thinking? Can't have these jokes and stuff. Stupid.
The Commonwealth also put on an expert who said that she found no injuries, none, mind you,
0,
indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. The Commonwealth cannot and did not.
See, the medical examiner, Scordibello, says no injuries from a car. And then they bring in Dr. Welcher at the end to just randomly say, oh, no, there's injuries consistent with a crash. And we're like, where are they?
Say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence.
Right there, that's reasonable doubt to me. And that's why this case should be, like a directed verdict. Directed verdicts make a ton of sense on paper. Wait, what? They make a ton of sense on paper because when you talk about them, you're like, okay, well, the state failed to make its case because they missed this element. And you go, you don't have an expert that can actually testify to this occurring. So you missed the element. So it should go away. But they never do. Like the judge doesn't want to do that. So apparently someone, I guess they found out that you can see the Grok conversation, so they contributed to it. I don't know what this is. And it says, Kurt from Uncivil Law gave us this awesome visual aid. It totally distracted me from his micropene. Uncivil Law says, sometimes when you're driving backwards at 25 miles an hour, your Lexus SUV can go to space. It's a possible hazard, and not enough people are talking about it. I agree. These Lexi just launching around, we can't have that. That is unsafe. Very unsafe. I love that Kurt's using AI now. Are you watching?
Nicker, I used to direct midget adult films, and even the midgets didn't have micro peens, but Kurt do.
The 16?
Kurt's earth animal spirit name is probably Crow Peanut.
I didn't catch it at first. How terrible am I? Like, what is wrong with me? I was like, M. Crow. I don't get it. Now I do. We're up to 17 on the micropeens. Coming to you live from central Minnesota. 17 micropeens on the half hour coming up. We'll see how we're doing. Okay, back to this. Back to this morning argument. This is the argument this morning of Alan Jackson trying to get a directive verdict of not guilty, as his claim is the state did not make its case against Karen Reed. I think it's a perfectly reasonable and rational claim, but he's not going to win on it. Judges really don't like doing this.
Evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love struck.
Yes, there is.
Jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe.
I'm a lot of fun. I'm a fun guy. I'm a ton of fun. I'll give you all the beach life you can handle.
Again, there's not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian.
Well, she's watching the wrong show then.
Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe
I'm about to go make a sandwich in a minute.
Not in the vehicle when they
Between
were
arguments, I'm going to go make a sandwich real
dome
quick.
light was on.
I'm hungry.
They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage.
Oh, shit.
Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning.
Yes, Tack,
Not
everyone's
one.
at lunch.
Not until Karen Reed found
Lunch
Mr.
goes
O'Keefe
to the hour,
at
so we
about
got another
6:03.
30 minutes or so.
And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body. The only person to have physical access to John O'Keefe testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion.
Why not?
Hearken to the video at CF McCarthy's. Hearken to the video at the waterfall.
I'm going to harken to the bathroom. Holy shit. I thought I could wait. Damn it.
Confirmed what our eyes could see. That night, John O'Keefe.
I'll be right back. Sorry, I'm back. I swindled Lady Rackets into making me a sandwich instead of myself. Okay, here we go.
Karen Reed were loving, caring, affectionate.
There's Brian Higgins.
There's
starts.
absolutely
He's
no
driving
evidence
right
that
now.
Karen Reed had an intent to harm John O'Keefe or that she absolutely, that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2.
We're sorry
because
you're
of the
back,
mens rea
too.
associated with counts 1
I
and
love
3
you.
fails
Thank you.
miserably. The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed.
Damn.
No reasonable jury, harkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3.
I
But
agree.
taking count 1 and 3 aside,
Especially
those
the
are
DUI.
separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John
None.
O'Keefe, or that she intended to leave him for dead in the snow?
Say
The answer is
depressing
none.
the brake
Zero.
or the gas
No
pedal to
reasonable jury
75%,
could find Karen Reed guilty.
which is
This
not,
case never should have been brought in the first place. There are
in
reasons
my opinion,
that I won't
sufficient.
go into here. The court knows those reasons or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts, and certainly taking count 1 and count 3 aside, the court is duty bound to dismiss those 2 counts. Thank you.
Dismiss it all or dismiss at least those 2 with the mens rea requirement. Basically says keep the DUI one in, but I don't think they made the DUI case, personally.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication.
Yeah, the first issue that the court should look at is intoxication, and how the only thing that you have is that Karen Reed was intoxicated, but maybe below the legal limit still. Several hours later, 5 hours later, after driving, they cannot prove at all when she became intoxicated or how intoxicated she was within 2 hours of the test. Typically speaking, like, well, in Minnesota, driving, or I guess testing over the legal limit within 2 hours of driving is the problem. Like that's when a criminal act has occurred. Beyond that, it becomes impossible to say when someone became intoxicated, if they stayed intoxicated, how long they've been intoxicated. All of that goes away, and the only thing they have is the fact that there were people drinking with her, and they have some conflicting and confused claims about the amount that she drank. But we don't know how that drinking affected her, what her blood alcohol content was. We don't even know if she finished her drinks. We don't know, we don't know if she drove before or after becoming intoxicated, if she became intoxicated at all. It's all very, very messy.
Kurt does in fact have a micro penis, but can we move on to something more verifiable? Look at your weight problem, you fuck.
It's a good point. It's a good point. Think about what you did, Kurt. Think about it. All that eating. There are people starving all over the place. You make a piece of casseroles like it's no big deal.
A reasonable fact finder would find that the defendant was in fact intoxicated.
Fact.
Based on the serum conversion.
How? The serum conversion.
And based on
The serum conversion is not forensically recognized for use at trial, and the serum conversion contains a margin of error up to 18%, and applying that margin of error backwards, as we've discussed before, actually brings her below the legal limit, which immediately raises reasonable doubt. Like there is no question that there's reasonable doubt on her level of intoxication. They have no other thing than an intoxication level with an 18% error rate, and that 18% error rate would bring her below the legal limit. That should be dismissed. That case should be, or that charge should be dismissed based on that alone. They don't have any supporting evidence that she's intoxicated at the time that she's driving. They have none. They know that she went and drank, but they don't have a BAC. They don't have field sobriety tests. They don't even have eyewitness testimony to the level of sobriety or her ability to drive. So to suggest that they've made the case for the DUI related, the DUI related killing, I think that's impossible. That should be dismissed out. But hey, I'm just a humble man. Who's this?
Eat poop. Bundle of sticks. Here's some funds to buy a tweezer for your micropene, Nick Air.
Thank you. I needed those, or I needed that.
Karen Reed's statements herself. You've heard many, many admissions by the defendant.
We're at 19.
About her level of intoxication, which far surpassed.
We're going to get to 25
statutory
micropenes
mandate,
today? That'd be amazing.
that she consumed alcohol in a way that would affect her ability to operate safely. Those are just two of the cornerstone pieces of intoxication, which are clear, light, most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus from her shattered right taillight that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming.
No, it isn't.
It is a public way. Lieutenant Gallagher told us about Fairview as being a public way.
So, what does it being a public
So
way
as
have to
the
do with
operating
anything?
under the influence of alcohol, manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard.
Where's the evidence she's intoxicated?
For OUI manslaughter.
At the time of driving, not
Regarding
5 hours
second-degree
later.
murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells
Driving a car forward and backwards is a clear indication of intentional death. It's fucking crazy. The state attorneys will just sit there and say stuff like this sometimes. It's just nuts. Like, I mean, she drove a car backwards and forwards. Yeah? Like, everybody does this every day.
F is for flirting that Brian tries to do. U is for you and me. N is for not John. Brian's a ton of fun right here with Karen Reed.
Oh my gosh. Brian Higgins is he's a superstar for me.
us herself.
I wish he testified.
Through
in this
firefighter
week.
Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis is about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three of them. On the other topic that we were discussing at sidebar, I don't need to hear argument on that right now, Ms. Giannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan?
I'm ready.
Okay, so.
Thank you.
All right, so we'll bring the jury in. That will take 5 minutes, Paul. All right, so we'll take the lease.
All right, please.
So there we go. That is whatchamacallit. That's the morning arguments over the motion to dismiss. Obviously, again, I say obviously because it almost never works, but they have to make the argument and then they're obviously going to lose. That's the obvious part. JNOV is judgment notwithstanding a verdict. Well, no, that comes at the end. That would be the end. Directed verdicts halfway through the trial almost never happen. So, but you got to make the attempt. And there you go. We saw it. We knew she wasn't going to get in. And then, of course, we've gotten into the testimony, the defense's case in chief. And Bev Canoni is already making it exceedingly difficult. There's a couple things I wanted to show, though. Let's see, what do we got here? Hold on, I'm looking for it. Hold on, where is it? Okay, this is driving me crazy. I had it there just a minute ago. Let me go to Turtle Boy. So I just have a brief video that we'll pull up from Aiden Kearney, aka Turtle Boy. The First Amendment got a big W from Mark Randazza and other lawyers like John Mateus, who interviewed both of them. Go check out their interviews if you have not. First Amendment got a nice little victory, and so here this would have been illegal yesterday or the day before. It shouldn't have ever been illegal, but people were getting arrested for this. This is it. Look at this. This is the protest or the demonstration or whatever within the buffer zone. Aw, there's Karen Reed giving someone a hug. Yeah, so we have this, and again, this would have been put to bed by the police as late as yesterday. Thank you. And so to have this is just a stupid reminder of what what some of these lawyers are out here fighting for when they fight for the First Amendment and what it looks like. These are just normal people who are out. They're not being crazy. They're not, at least not in this 30-second video. I mean, I guess the rest of the day, they could be that like Femen group where they rip all their shirts off and start screaming and pouring blood on themselves, which would be cool and metal. But they're not doing that. They're just people who are out there. They're just out there. Like they don't even have signs or anything. They're out there seeing what's going on. And to know that that's the type of people that were being arrested. And this is the activity that was being prevented with the use of law enforcement is pretty disgusting. Gillian Seed says this line of Coke is on the farms. Rackets, $2. It's not a very good one. Let's see. What do we got?
Can you give a quick update on how the defense witnesses are doing on direct and cross? Just woke up.
Well, there's only been one witness so far, and I think he's doing just fine. His job was to evaluate the report of Shannon Burgess, and his evaluation was that the report had some deficiencies. He didn't come out, though, and just say it was utter garbage and trash. He didn't do it. He wasn't disrespectful or anything. He just basically came out and said, these are the errors that I saw with the report. He noticed that the first problem that he noticed was a misuse, or I guess a misunderstanding of megabits versus megabytes, or gigabits versus gigabytes. And that is what tipped him off to, start his analysis. And then as he went through, he found the report to be deficient. But like I said, he doesn't sit and trash it. He kind of rolls with some of the ideas that are in there, like variance in the times, the time between a cell phone and the Lexus clock, which still weirds me out that there's not a correction going on every time that iPhone connects to the Lexus, like that it's not borrowing the time from the phone. And if it is, why do we have so much variance being repeated every time it's turned back on? Then it's very strange. But I don't know. Other than that, he's been doing just fine. He's kept his calm and his composure. Hank Brennan hasn't been too nasty with him on cross yet. I mean, Hank always sounds irritated. Can I call him Hank? I feel like we're friends. He always sounds irritated, and I don't know if it's just an affectation of the Northeast, because you kind of see it in mobster movies and stuff like that. But it's like, yeah, what are you doing? You doing this? This is what you're doing, right? You're doing this. That kind of it's an aggressive approach. It's not passive aggressive. It's aggressive. It's accusatory. It's got a particular feel to it. Sorry. It seems aggressive and accusatory from an outsider, but maybe in the Northeast, like that whole, like, know what you're doing. You're wrapping my sandwich wrong. You're wrapping the sandwich wrong. Do it right. That's the impression that I get. And maybe that's just a normal affectation of the local vernacular. I'm not sure. Someone from there would have to tell me. It's a very Northeast Metro thing to do, says Brad Pitt. Tatsi Fay says, what about Karen's phone GPS? I don't remember them using that. Yeah, I don't. Well, I think within the Waze app, they use the GPS from the Waze app. There's I got to keep this on. There's closed captioning going on, but there's no actual volume or sound coming through. So I'm not sure exactly what that is. We have a couple minutes before court is supposed to come back. But I'm watching it. So is it 4 monitors or 5 in the office? Mine? I have 3 monitors. I mean, my main monitor is a 43-inch monitor. That's what I'm typically looking at. Down in front of me, I have a 24-inch 4K drawing tablet, and then up here I have a 27-inch monitor, but it's only 1440p. It's not a 4K. It's an old gaming monitor that I use for. Obviously, I use for this now. I don't know where else I would put it. Like, in theory, it's like, oh, it'd be nice to have another monitor or something, but I don't know where I'd put it or what I'd use it for. So I'm not sure why I'm like thinking it would be cool. It wouldn't actually be cool. It'd be completely useless. Or I'd be like looking way up like this. I already have enough ceiling cats. I can't keep doing that. That'd be bad. There was something I wanted to do. What was it? Shit. Everybody's laughing right now in court. I don't know if you guys can hear it. It's really quiet. Kurt graduated Clemson in 2004. Law school? Or is that undergrad? I graduated undergrad in 2005. Oh, hey. Yeah. Someone said eat a sandwich. Lady Raggets brought me a sandwich. Now, if you want a hot triple decker, you can watch my sandwich recipe. You must be double the age of consent to apply for a triple decker sandwich from me. Okay, no, that came out, but I mean an actual sandwich. Okay. Ceiling Cats, where's Sunny Dog? Right now I think she's outside playing with the kids. That's what was going on when I went upstairs. So I would assume that's what's still happening. If you base Kurt's age on weight, he's 75. I don't know why that's so, like, that's worded so funny. So anyway, It's okay to be a dude and make a sandwich. The greatest chefs are men. I mean, it's a sandwich. Sandwich is just stacking things up. You know, or I guess you have to spread things from time to time. But it's pretty basic and straightforward. Anyone can do it. I believe in you. I don't think that's a gendered thing. But where were we? Oh, so I mean, I've talked about basically what's happened today. Again, I think this witness is doing really well. I think he's keeping calm. Hank Brennan will start to lose his mind in a little bit, probably, which will be funny if this guy keeps going. But the star of the show today, of course, is Bev Canone, denying the motion earlier and then sustaining every objection of Hank Brennan during the direct examination conducted by Attorney Jackson was a little bit much. Let's see. What do we got here? Yeah, Grifty, I'm glad that it filtered that out. That's a disgusting that's a disgusting set of chats. I don't want you to send that in. Sandy Brown says it's definitely gendered. I know women are supposed to be good at making sandwiches, but I suck at it. My ratios are always off. There's a common misconception, though, that women are supposed to be good at making sandwiches or better than men. No, it's just that women are good enough at making sandwiches that men can, get back to what they're doing if a woman is making a sandwich. It's not about who's better or worse. It's about the utilitarian nature of men and their preferences. Like they're eating a sandwich. Most of the time, they're not really looking for a gourmet experience. So the, constructive ability of putting a sandwich together is satisfied by, by most women just fine, even if they're not particularly skilled culinary artisans. Of course, culinary artistry in all of its forms should be appreciated and highlighted by men as they, particularly enjoy something made for them by a woman or anybody. Tell them that they make good food. Let them know it's important. That being said, I think we can just take the making of sandwiches out of the realm of culinary gendered competition because it's not about that. It's not about that. It's about getting food in your mouth in a way that's great. Like, we can have a sandwich making competition. We can do that all day. I will make the sandwich. I don't want to say I'll make the shit out of a sandwich. I will make a really good sandwich. Kick your sandwich's ass or whatever. But we don't need to do that. We can approach this in peace and just stack stuff on bread. Realize how good that is. Whoever thought of that, they're like, we got all this bread. Let's just stack stuff on it. What do you stack on top of it? Another piece of bread. Holy shit. What have you called this? Sandwich? Where'd you come up with that? I don't know. Who made the first one? I'll give you all the sandwich life you can handle. I need to upload that song into my StreamYard to have it as a drop. Or I'll have to get Ryan to make it into a video of some sort. I gotta think of a thumbnail for that too. Because there is a video of me using Grok to write the song and then getting the song and reacting to it. So that's ready to go. I just need a thumbnail for it. Lolita Smiles. Let me help you out, girl. You said you're a good cook. No one in your family appreciates it. They do. They appreciate it. I would wager they just don't know how much it would mean for you to hear that they appreciate it. So that's on you. You got to train them like dogs to give you praise and worship at your feet or whatever. But I think once you do that, you'll find that, and that's normal, by the way. It's normal to like want praise for doing something for other people and just be like, you know, someone to say, hey, thanks, I really like this. So don't feel bad about it. They probably just, it doesn't enter their minds, and that's okay. It's not because they don't appreciate it or think like less or don't think of you at all. It's just that they're not used to expressing it because they're just used to eating. Eating is something that we do all the time. And I think our brains just kind of filter out our responses to it unless we make eating a special event, like if you're going to a nice restaurant, etc. So just let them know. Just be like, hey, do you guys like the food? If you do, just tell me sometime. Say, hey, thanks. Assuming you're, based on your name, assuming you're the lady of the house. Just say, hey, thanks, Mom, for making this food for me. And then say, you little bastard. Call him a little bastard. That helps. Be like, you little bastard. Say thanks. Especially if they're under 5. We got noise from the courtroom. It's me again. Sai says, thank you. So easy to say. Yeah, but eating is something you do multiple times a day. Like,
Whenever
you just
you're ready,
get
Mr. Brennan.
that there's a thank you involved unless it's made special. But you don't want the thank you when it's special. You want the thank you for the every day. It's just it's like a conflicting struggle outside. I don't know, whatever.
Ms. Gilman, if we could turn to page 6 of Mr. DeSorga's amended PowerPoint presentation. Sir, I want to ask you about your opinions, and inevitably some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition of the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
The data from the SD card correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is with the other chips part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So that 3 seconds that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on, the infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the
You thought
screen
they
comes
sent
on.
everyone home for the day? No, it's just
Yes.
lunch.
Okay. Now you've made some
Still have
slides and
2
you've made
hours.
some assumptions suggesting that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically, he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said.
What?
Where
How
in
do
the
you
report
how do you exactly not?
Where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Jesus.
So when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess's report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to
I know
shout.
that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
Okay. The time that you're adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding
You're double dipping. These
you're
nuts.
adding 3 seconds that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra. It's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then
That's for
what
chat.
you're saying would be
That's for you
correct.
guys.
We wouldn't account for any delays because then it's
Here I
already
am.
baked into
I'm
those
helping you
numbers.
out.
This is a very unique analysis. This is not something I've ever even seen, this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key on event in a Lexus infotainment used in addition to the key on timer from that same Lexus.
You know, Mr. Burgess actually looked at the data, not just the timestamp. You looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point. It's a derived value from the key on time, and then added to that is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You look at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so they're not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3-second delay that now you're saying might not even be accurate. Is that fair to say?
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3-second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key on timer happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but not this specific Lexus.
I'm sorry, finish.
No, I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. Had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same or is it unique? We don't know. The answer is we don't know.
And so when you are determining that 3-second variance, you don't have any assurance in your own mind whether or not this car, Ms. Reed's Lexus, has a 3-second variance. That's what you're trying to say.
That's correct. And that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now, let's turn to slide 9. As part of your charts, could you enlarge to the left, please? As part of your charts, you took this chalk from Attorney Burgess's report and you made some assumptions about this, didn't you?
I mean, he formed opinions.
I'm not sure.
Okay.
I applied the numbers in his third column to the times. So, I mean, that's the extent of the analysis.
When you looked at the first
and that's
5
the extent
columns,
of the analysis.
1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45:12 a.m., and 5:04:28 a.m. You said on direct examination, oh boy. You said on direct examination that was matching infotainment to iPhone.
That's what it says on the chart. So
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
Is that your opinion that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're basing your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matched to John O'Keefe's iPhone or some other phone matched to John O'Keefe's iPhone? Did you do any independent studies about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m., the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those
Oh, by the way.
the first 5 times where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 calls. Do you know where that information came from?
It came from the SD card from the infotainment.
Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
Bum, bum, bum. Hing is trying to pin him down, but he doesn't have anything to pin him down with. Oh, shit. That was quick. I didn't know they could do sidebars that quick. Say bye.
Do you know the genesis, the source?
Oh, is that what Genesis means?
For numbers.
Definitively no.
Your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those are all phone calls from the defendant's phone to Mr. O'Keefe's phone?
Yes.
You did know that.
I know that they're phone calls
From who?
between. Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So
Do you know where those calls came from? The source.
a phone,
Whose?
Miss Reed's phone.
Now, I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, you plug your phone in, it's going to register on the infotainment system, but come from the phone? Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know,
If you don't
then
know,
your conclusions and all
Yeah.
your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure, if there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that when an iPhone is plugged into a car, it downloads the information from the iPhone on the infotainment system? Did you know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a predicate you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
Objection.
But
So I'm going to strike that. Go ahead and ask your question.
I apologize. If you have two different devices, a Lexus clock, the infotainment system, and an iPhone, you would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion, you agree that you'd expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
Two iPhones?
Yes.
No.
So as you sit there today, you don't have any expertise, any education, any knowledge about how closely two iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small? 2, 2, 1.
does he need to?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other? Objection.
Sustained.
You just established that he doesn't know this.
About whether iPhones to iPhones will generally be within 1 to 2 seconds of each other. Objection.
You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree with all of your assumptions and conclusions are inaccurate.
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the
You
answer.
don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Sustained.
Jesus.
This is iPhone to iPhone. Then your assumption on the first 5, 1, 2, 2, 1, 2, 1. If they're iPhone to iPhone and you're wrong about the fact it's infotainment iPhone, your assumptions and conclusions are inaccurate, aren't they? Objection.
I'll allow this.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts would be inaccurate, wouldn't they? Objection.
Sustained.
At 5:21:36, do you know whether or not the defendant's Lexus was on?
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Yep.
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase, again, Mr. Birch's report as I recall it, in that he stated during the testing they did with the exemplar, calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed, there were 2 call logs in Mr. O'Keefe's phone, but only one timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at phone records?
Did you ever look
for
at
the defendant or for Mr. O'Keefe to make a determination whether these are 2 separate calls or not? Did you ever do that?
No.
If these are 2 separate calls, can you explain to us why there is one timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar vehicle, was it?
This table, no.
No. This information was taken from the infotainment system of the defendant's car. Isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone. Isn't that true?
Yes.
And so, you know why there would be 2 phone calls and only one timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Did you know that?
Yes.
Well, if you know that, can you conclude that even though there's 2 calls and only one timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that that's how it works.
So when you look at 5:30:15, bottom middle, and 5:30:52, it is impossible to tell which one relates to the 5:30:31 infotainment on the left. Compare. It's impossible, right?
Yes.
So there's 2 possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity in those. Correct?
I'll allow that.
Is there a 27-second disparity when you compare the 2?
I'm not sure I understand the math.
5:30:31 is 16 seconds different than 5:30:15 on Mr. O'Keefe's phone. Yes?
Yes.
5:30:31 is 21 seconds different than the 5:30 phone call. Yes?
Yes.
And the difference is cut each way, one's minus, one's plus.
Correct.
So you add those disparities, you get 27 seconds, don't you?
I'm going to allow that.
No.
What do you get?
You're saying if maybe so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
how many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the next car was turned on at 5:07 a.m.? Is that ringing a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable. Yes.
When I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay.
How do you do that without fingers? I don't know. It's amazing.
If those first 5 calls were iPhone to iPhone rather than infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Yes.
If we turn to 10, please. Given, could you zoom in a little, please, on the left?
Who was that? That was a
Given that
big-
these
big
data
breath.
points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30. Did you consider whether they would be less reliable than comparing to the triggering event, the 3-point turn at 12:23 the night before? Did you consider that?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 1162 at 12:30, 1:43 to 48, than the 3-point turn?
Yes.
Okay. When he explains that the method of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report.
Yes?
Yes.
You shrugged. I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. But I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy? Would you like me to bring it?
Do you
to
have the reports with you, sir?
Okay.
Do you have an extra copy for him, Mr. Brennan?
Mine is marked. You want me to show the mark? Let me see if I can get a clean copy from the witness. I don't have a clean copy. I don't want to show you something that has my writing on it. Not that I care that you read it, but it's protocol. Okay.
Why do the timestamps matter?
Discussing
Well,
why
under
this
one,
is not an effective way of matching the time. Did you consider
under
in
one
his May
timeline,
8, 2025 report, when he's talking
John is
about
in the
this
car
method,
when some of this stuff happened.
when he says, as a
Another
result, this
timeline,
method
he's not.
yields a single reference point for potential alignment.
Yes.
And when
Call
he
logs
talks-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, which is referring to the 5:30:31.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a clock speed of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Consider that.
Yes.
This offset is measured approximately 5 hours after the time of the collision and cannot be assumed to apply to other time frames stated in the initial report. Objection.
I'm going to allow it unless, do you have, I'll see Counselor Tadman.
Back to side back.
I'm not a Muppet.
What? I'm not a mup. I mean, I'm not. I just don't understand why there was a need to tell everyone else. It's very weird.
Is Karen Reed single? And do I have to be a cop to get with her asking for a friend? Also, micro peen.
Yes, you do. You have to be a cop or an ATF agent who's a lot of fun. Let's see, what do we got here?
Brennan is a dick, and his voice makes me want to jump off a QLF. I love his micro peen.
A cool I laugh. Love his micro peen. It's just so perfect. So Brennan is trying to put pressure on this guy. He's right as he started, I was like, oh, he's doing okay. You know, he's doing a fine job. He's not being a dick. And then he started being a dick. It was like, come on, man, give me a break. I'm out here trying to give you credit or whatever. But no. Yes, you are. Megan made you a Muppet. She did not. If she made me a Muppet, I'm going to sue the shit out of her. We are back. My bladder is dying. I think I must be getting over something.
Sir, going back to my
What is this?
question, so you read Mr. Burgess' report, the
When I
same
get
report that you're critiquing,
mildly ill.
and you were
We'll be back
aware
in
of
just
this
a minute.
information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information
for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy. Does he have the clean copy?
You can turn to page 3. What I read to you was where it says clock sync method 1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only 2 data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Okay. Because you still are under the mistaken belief that
Sustained.
you still have the opinion that the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization. Okay. It would change the total number of possibilities.
So if we put up chart 12, page 12, please. If you were wrong about the infotainment to iPhone analysis and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
And if we turn to 14, please. And if you could enlarge, well, I don't think you can enlarge it. If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
And the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as queuing it from the 3-point turn event 11:62:1.
The 3-point turn is closer in time than the call at 5:32.
And thus more reliable, wouldn't you say?
Generally.
And the negative 21, that was from 5:30 and some seconds the next morning. same idea, not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes.
He didn't just have it in his head. He put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
Yes. Exhibit 192A.
What's up, Freedom?
Let's start with 192B, please. If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the 3-point turn event as timestamp 154, that actually is at the beginning of the 3-point turn? Do you agree with that?
I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
Okay. And it notes that.
So ask it differently, Mr. Bowman.
Does that heading note the start of the 3-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the 3-point turn maneuver.
And then the heading of the change, end of 3-point turn to O'Keefe's home, 12:24:07. Do you have any information to suggest that's not spot on accurate?
I did not analyze the 3-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the 3-point turn conclusion? Did you consider that?
I'm going to allow that, yeah.
Oh, you're going to allow that? Because Hank asked, so.
I'm not sure I understand the question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a timestamp for the end of the 3-point turn.
Yes.
Based on Mr. Burgess's May 8th report and based on the data, which you don't contest, you now agree that 154 was not the end of that 3-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate? Are you suggesting it is in any way inaccurate?
I'm going to allow that.
Why?
I don't have any opinions as to the individual accuracy of the methods selected by either Mr. Burgess.
Great way to
Do you
answer
have
this.
any information you'd like to add or weigh in on to dispute the
That
accuracy
was a great
of
answer.
those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. You could open that. The 154 timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Sustain. Strike it.
In the final exhibit? Let's go back to the data.
You need
said that Mr.
Adderall to
Burgess
stay awake?
had
No, I
an
already had one.
8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range? Objection.
So ask it differently, Mr.
Okay. You suggested the reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a
This data from the green, would you agree it indicates the beginning of the three-point turn, and then the orange is at the end of the car is already in motion at 11.2 miles per hour? Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed
Why not?
yourself, right? Before you came in and gave an opinion.
I could have.
But you didn't.
I did not.
Do you have any reason to test the accuracy of this data that's been broken? No objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, wide range, right? Even though this analysis depends on the end of the three-point turn, would you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the three-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Green.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct?
And so if Aperture's position is the matching times at the end of the event, going back to the beginning, isn't that even more forgiving than the debate scientist's suggestion?
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
The opposite of cherry picking, right?
Sure.
Do you have an opinion to a reasonable degree of forensic data certainty about whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or
Good
touching
try,
between
Hank.
vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendants vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really
I
hear
don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's
You're-
19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Okay.
Whoa, then finally. Redirect.
Yes.
Thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen.
I mean, it's not officially burden shifting.
Um,
The defense has no burden.
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
Mr. Sogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report, the
So-
May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
He did it first. I was only following his example. I'm just kidding. I'm on this guy's side.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at a chart?
It would. Thank you. Yeah, there are a lot. I would have to really use my finger to count them all.
Okay, more than 8,
Total after 1162-2.
only on the 29th.
There aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say there are many, right?
Yes.
May I approach?
Yes.
And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you. I want to ask you a hypothetical, if I could, based on questioning by Mr. Brennan surrounding the 12/32/09 lock event. Do you remember him asking you about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12/32/16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12/32/09 to 12/32/16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them.
Okay,
all 30 of them
cool.
would occur at a point in time. Let me rephrase that. All of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you. If you were told, to give you another hypothetical, if you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12/33/14, would that impact your opinion in any way?
Objection.
Sustained.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess?
Hold on.
Of course.
You need to, we have to turn the fans off.
And I'm not speaking loud enough.
Right.
I'm sorry. I'll raise my voice. I just don't
Oh
want to
yeah, yo,
scream over
yell at
people,
me.
but I will raise my
I've been
voice.
missing a Lessie. Yell
Try
at
this
me.
first.
May I start again?
That question, yes.
Thank you. You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte, And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data, or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing, where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event,
Key
that
on.
Stopwatch, stopwatch starts running. Timer.
In the VCH system, yes.
Okay.
Derek Boot will know it was connected to a bomb in the
Is
tail
there
light.
an infotainment system that also has a timer or a clock on it?
As a clock.
Are those two things independent of one another?
Completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis,
We're arguing over seconds.
did he align the two vis-a-vis the 3
I guess they matter.
No, he did not.
With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DeSogra's PowerPoint. Can you highlight the table on the left, Mr. Wolf? Thank you. Did you create this table?
No.
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
It was. It was
Did you type-
it was a screenshot.
Thank you, screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it.
Yes.
You didn't type anything on this.
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment, call, timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
Objection.
Sustained.
What?
Did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustained.
Why? Why is that objection sustained? That's not a leading question. It's just a yes, no question.
May I have just a moment, Your Honor?
Sure. Do you need the light on?
I don't. And we can pull that down. What was your entire analysis predicated on? What was it based on? The foundation of it, as you explained your analysis to Ms. Steer during the course of the day.
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No,
Did you change any of their analyses?
no,
Did you explain their analyses?
yes.
Sustained. Ask it differently.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and the presentation to the student?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? Remember being asked that by Mr. Brennan?
Yes.
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
That's correct.
You were also asked why you believed Mr. Burgess did a quote unquote more detailed report in May versus January of 2025. Remember being asked that just a few minutes ago?
Yes.
Sure, Tack. Either that or I'll do that in my
When
recap
you
video.
presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting?
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
So, Mr. DeSorga, this demonstrates the danger or the difficulty.
Hold on. Start the
It's
question
cross-examination.
differently.
It has to be a question.
Start.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
No.
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
Of course you can.
I don't think that's true.
When you're looking at, please.
Experts do that all the
When you're looking
time.
at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
No, not fair.
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides itself or resides on the infotainment system, correct?
There's a transfer of data. Yes.
And so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's.
And so when you
No.
don't actually do the work
No.
yourself, and you just presume,
Wait, what was that
Yes.
answer?
you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, with a reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself rather than just Monday morning quarterback and somebody's report. Objection.
So I'm going to strike it, ask it differently,
If
Mr.
you
Brown.
actually did the analysis yourself, you wouldn't have to make a presumption that it would be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the testing.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No,
Did you read Ian Whitten's report?
no,
You don't know if that testing was done, do you?
I don't.
It's not in the reports, though. That's the critical aspect
I
of
do
it.
not, sir.
And so if you're wrong,
If it's not in the reports, it's just as well not done.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If you
question.
have the wrong data when you're doing your analysis, then the final analysis is going to be wrong. If you have using the wrong data, it's that simple.
Yes.
Right? You don't have to be a scientist to figure that out.
Yes. That's
Okay. If we could have Mr. Welcher's 33. If you could open that, please.
He's calling his own data wrong. Like what's going
You
on
were
here?
asked about whether the window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds right in those first couple of lines. Yes.
Yes?
Yes, I see
Yes.
vehicle speeds.
If you go to
Yes.
the bottom, at the end,
Sounds very excited.
the car is still moving. Yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving.
Well, no,
Yes.
the 38
At
would.
the end of the record, there is a vehicle speed. The car is moving. That would be my assumption.
Okay. And so when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data. Yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window. Yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real life event.
Yeah, absolutely. The end of the recording.
Okay. And so after that window, 12/32/04 to 12/32/12, you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember you were asked about that?
Yes.
Did you know at 12/32/16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12/32/12, which is in the 10-second window, and 12/32/16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Okay.
12/32/16
Wasn't just that Mr. O'Keefe's phone was moving, there were steps.
I didn't review the phone data, so I don't know.
Did you review anything to indicate that steps were taken over the course of 50 feet? Objection.
So that's sustained.
You were asked just a second ago, what about the data? What was wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
All right, Mr. DeSoger, you are all set, sir.
Oh my gosh.
Want to see counsel for a minute? Jurors, feel free to stand up and stretch if you'd like.
Here we go. We have a couple super tips.
This little piggy will be on the Who Are These podcasts channel today at 4 p.m. Eastern. We will be
my
going
goodness, it's
over
coming in.
exactly how much time Toast spent on Kiwi Farms and what pages B was on while on vacation.
Oh no. Oh no, don't do that. That'll be funny. Guess you guys can check that out if you want to on Who Are These Podcasts. I will not be on it to my knowledge. I've not been invited. I don't particularly want to. I'll be on with Zia tonight at 8 p.m. Central, right? And let me make sure I'm correct on that. Yes, 8 p.m. Central Time. I'll be on Zia's channel for Unqualified Experts, where we take people asking for advice or asking questions on Reddit that neither of us are qualified to answer, and we will do our best to answer them.
The evidence will show that it is possible to have discerning legal insights while making jokes about a cheesy frenulum of a certain micropene. Nick, thanks for making law fun again.
No problem. My pleasure. Sorry I took a break. Sorry to leave you guys, such dry content. I like a lot of these people, don't get me wrong, but we just have different styles, and that's okay.
PayPal, Venmo, Cash O, Streamlabs, Rumble Rants, supertips.gg/RL, and Kurt's Micropene is how you donate today.
That's true. That's how you do it.
This is weird. The state has unlimited funds, but hires experts with no credentials. Meanwhile, the defense has limited funds and their experts are not retarded. How is this possible?
It's like watching David vs. Goliath, but Goliath needs a special bus, and David is 7'6", 325 pounds. Your Honor, what the hell is going on?
Be right back.
Now or not, and I'm going to let you go. So that 5 minutes that just took means that you get to go home because we know we'll be longer. We don't want to do this to you, okay? So we'll break for the day. I have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Additional caution, please be very careful. Continue to be careful with your social media use. We will see you Monday. Monday will be a full day. We'll start right around 9 on Monday morning. So we'll see you then. Have a great week.
Please rise to the jury.
Chrissy? We'll come back. I'll come back in 5 minutes for the voir dire.
Okay. What did I miss? What just happened? Voir dire. Who are they going to voir dire? This guy?
Just want to say thanks for doing this trial. It's effing good to have you back, Nick. Kurt Micropene, etc.
That's 24. 24 on the micropenes. This is from Sport Nugget. I hate prosecution run like defense. Well, you don't know this didn't happen, right? Right? See, jury, she could be guilty. Find her guilty. Yep. Garbage. Garbage. Okay. Let's see. Julian Seed says, how can you live with the state of the house? I don't know. How can I? It's kind of, I mean, like, it's a mystery or whatever. Project Calm says, quoting Brennan, please tell me you did some testing. The state needs at least one piece of evidence, not proctored, gathered by a retard or fraud. They should get proctored added to Webster's. That'd be great. They're going to voir dire Proctor's friend about text messages? No, they're not. I hope so. We are at 23 micropenes. We're close. I don't know if we're going to get to 25 today, but we're hoping so. Hoping so. Also, hit the like button if you're enjoying the stream. What does voir dire mean? Voir dire means to examine someone for a particular set of knowledge relevant to the case, basically, in short, for this purpose. So they're going to take the expert and ask him some questions to see if he knows about something, to see if they should bother pursuing it in a line of questioning. Does that make sense? So if the prosecution has something that they want to get out of, or it can also go with excluding testimony to find out if they don't have personal knowledge about something. So if the defense wants to get their next witness to offer up some piece of evidence and the prosecution thinks that they don't have personal knowledge or aren't qualified to give an opinion on it, if it's an expert witness or whatever, they can ask the court if they can voir dire the witness to make sure that they have a sufficient basis for the testimony they're about to offer or any evidence that they're about to authenticate.
I'm enjoying cross exams so much better today. At least the experts answer the questions without trying to change the subject. BTW, you didn't leave us dry. Kurt's micropene just couldn't make it wet.
Damn it.
MICROPEEN for the goal.
Oh no, it's 25. I don't know what that means, but it is 25 micro penises. Micro peni, penises. I don't know. What do we do with this? What do we do with this power? This power that we have. I don't know. Okay, I need to come up with a thumbnail for the Brian Higgins song.
Hey, listen, I see you out there making jokes. This is hard work. These cops fucking sucks. So me not doing a full day of work is par for the course. It's not my fault this bitch can't drive.
That's true. That's true. So Karen Reed should have just run him over with purpose and intentionality. Like it just owned it. Like, girl, if you're going to murder him, just flat out murder him. Oh, did you guys see the Nashville shooters, man, like notebook was just released by the FBI, or not Nashville. Was it Norfolk? I think it was Nashville. And I was reading it. It was really fucking sad. Because it had like lists of things to do before they, off themselves and killed a bunch of people. Like, and it was like, it was a child. Like it's a kid, and that's the sad part about it. I mean, they're a lunatic murderer. Go away. I don't mind that they got offed or whatever. But it's just sad because it's like shows I want to watch before I go, like the DVDs and stuff. And then you go through it and it's like just a list of like animated stuff and stuff geared towards kids to teenagers. And you're just like, Jesus, man, how do you get there so young? Like you're gonna watch like season 4 of Pokemon that you have on DVD, and then you're gonna go murder like you're gonna go attempt to murder people at a school. She's in her 20s. She's 28. Fine. But like, she's not. You know what I mean? Like when you look at that notebook, it's a child. I mean, maybe she's retarded in the true sense of the word, like held back mentally. I'm willing to concede that. Absolutely. But it's a child. Like that's not a mature person. There's an issue in there. It's like it's just like it's strange. Again, I don't have any like particular compassion for the deceased. I don't care. It was just like you read it and it's like, well, that's fucking weird. It's very I don't want to say humanizing, because it wasn't humanizing. It was so immature. Anyway. Like, why didn't you just watch more movies instead of killing someone?
Is a microdong just a ding, or should we just keep it micropeen, unbreaded?
Unbreaded. We got to find a way to get the unbreaded to have a proper pause before it.
I'm starting to understand why Mr. Pizza Casserole might be in a cartography category. Micro penis, having crusty hairline, having whale blubber, having brother butter loving ass. You are unmuted.
Crusty hair, having brother butter loving.
Was now open, maybe see.
Was there another school shooting? No, this one was a while back, Lolita.
You solemnly swear the evidence you give the court in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God. Thanks. You take the stand.
Thank you.
Oh, it's just,
I know this is a lucky opportunity. There is in this house.
is this Dr. Wolf
Sure,
again?
she's right outside the door.
Do you mind, sir, if you can stay right there? Sure. And it'll just be a few minutes, okay? Ms. Gianetti, when do you need this witness back? Monday?
The mutant says F Baldo. Okay. Bye. I guess. Like, I don't know. I don't know what that F means. It can mean a lot.
So I'm going to need her at a microphone. Do you have one on council table there? So the podium, or one of those back where Eugenia is. Thank you. No, there's a microphone a little closer. We're just follow the. Hi, good afternoon.
Hello.
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day.
Yes.
All right. So we're not going to reach you today, unfortunately, but you were summoned to be here.
Yes.
All right. So that summons is still good until we reach you. So you're going to have to come back Monday morning. Okay.
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay. Thank you very much. We'll see you Monday morning. Be here before 9. Okay.
Will do.
All right. Thank you very much.
Thank you, Your Honor.
Go ahead, Mr. Lessie. Oh, geez, you're an idiot.
That was a big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do
I'm
you
not.
know
Make him
former
wait
State
longer.
Trooper Michael Proctor.
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew
Was
up
he
with him?
retarded
Grew
then?
up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this
So
old guy.
can we turn off the fans in the?
So this guy's friends with Proctor.
We're just going to do that, sir, so that we can get through this a little bit.
Absolutely, sure.
This should be
Much better,
funny.
thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduate high school with him?
yes,
And are you friends after high school as well?
yes,
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes,
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay,
Okay.
may I approach?
Yes.
Would you like this marked for identification first, Your Honor?
Yes.
Exhibit N for identification.
And I'll do it back to the witness. Thank you.
thank you.
Thanks, Neuro. Is this guy like reading his life history? Like, what the hell? I've known him for 30 years. He's my best friend. Hold on, let me read this report so I can make my testimony. This guy's looking at the letters going, I don't know what these mean. I don't know what they do. So is this about the texts? Hold on.
This guy looks like Kurt when trying to find his micro peen.
$28 P9 today. There's still a day left to go. What are we even going to do?
think he's all set, Mr. Newman.
Thank you, Your Honor. Sir, have you reviewed that entire document?
Yes.
Does that look familiar to you?
Yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Oh, God.
And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years, definitely years.
And that's a portion.
Oh, you didn't know.
In other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Oh,
Now,
gosh.
I'd like to ask you about 5 different
There we go.
categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Well, do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes.
So as of January of 2022, you would have had a passcode to get into your phone, correct?
Correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end. And you don't have to read the actual text, sir. I just want to.
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay, and what you
I
type.
have a different copy.
Oh, I'm sorry. It's for the record. It's on page.
What's the bottom page number?
And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
sure,
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
So, I don't think it's necessary. Yeah. So let's not, if he recognizes, I don't want to put names out.
Oh, I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes.
Why don't you refer to the last 2 digits in the phone?
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment.
Yes.
Yeah, of course, of course. Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
That's
Oh, I'm
me.
sorry, that is you,
Yeah.
of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 93, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
So he's authenticating these messages from
With
Proctor.
regard to
Based on
whether
his
this
personal
is
knowledge.
a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
Okay.
Well, I mean, that's what he should need, but after yesterday, who knows?
Just one more question for you, sir. Does the text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Mr. Brennan?
Good morning.
Morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Nothing on that.
All right. So, sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
Get out of here. Go away.
Unfortunately, this witness was not reached by the jury today. I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right. Sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right. Thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So, sir, you can leave.
Okay. Thank you.
All right. And thank you, Mr. Campbell. We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
Sir, watch your step coming down.
All right. We'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I've got to respond to the
No,
objection.
I want to hear you as to why this is admissible. Why this is admissible.
That's fine, Your Honor. I just got a moment.
She has already decided, yes. I don't know why she's going to make him go through this argument.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence.
Ooh, that's a good approach.
The Commonwealth filed a memorandum in opposition to these text messages.
Commonwealth would
admitted,
absolutely do
and
this to Karen Reed if they could.
Not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it, and nobody discussed any of the emails with him. But the SJC cited a longstanding rule, including Rule of Evidence 901B1, for evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's
How they're going to bring any of these
the
texts in as
and
something other than hearsay.
We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in again because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement. So the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when,
So what is
police,
your exception
stop
here?
somebody on the street, or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. So I won't even.
Look, I'll
mention
stop
them.
if you're going to just let it go.
The Commonwealth is essentially.
You should just stop and say no, because she's going to say no.
We're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said a sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's gonna go down for this. We're gonna pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary,
state cannot let this
is anything going
in.
to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the
So we're going to use state of mind to overcome the hearsay
objecting to the
objection.
admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and.
They
go
must
through each
be
one. Just get me a
planning to
copy
call
of what you've
Proctor.
agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
You can,
Yeah, it says-
you
it says
can take
Julika's
care of
board
it and
design.
Email it in.
We'll do that. Thank you,
All right.
Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias, because perhaps it did affect.
I agree. They're going to have to call
the bias.
Proctor.
Perhaps the person was very biased and made decisions based on that animus.
I don't know how they get around
Or
calling Proctor to get this
perhaps
in.
the person made negative comments, but had nothing whatsoever to do with the investigation.
Unless they're going to
It is
argue
surmised to say
that Proctor's
because
statements
these
influenced
comments
this
were
other
made,
guy.
A witness was not investigated, or there was some other
That's possible.
amorphous, undefined ill that happened. That's the
Explain
whole
the state of
reason
mind
why
of
the
this
witness
guy
who
as a
made the
witness.
comments should be confronted with the comments they made, so the jury
Yeah.
can fully
Okay, so
assess,
that's
is
the end
this
run.
relevant? Is
That's a
it
good move.
material? And what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be
The
against
state
that witness
really
because they
wants
need
the
to have
defense
the
to call
opportunity
Proctor.
to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being omitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with
No,
the
I think it goes
adequacy of
right
the
to the
police
state of the mind
investigation. It
of
has to do
the
with bias.
witness they just voir
And
dired.
that purely is the state of mind of the person who made the comment. I
No,
would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation,
no, just
and it
wrong.
invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side, because it will lead to arguments about what it means without a factual basis.
He had a burn
And so
happen in his
my
brain.
position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Mr. Yannetti, do you want to respond?
I know we're the hour's late, Your Honor. I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate
Good.
text messages. That's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay. And just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule.
All right. So you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have no obligation to do that. We have no intention.
All right. So I'll get a decision out on that before 4:30. And I'm going to do a little more research on the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no. Okay. All right. I'll see everybody Monday morning.
Thank you.
For the court, please.
So yeah, the state didn't call Proctor because they don't want to do direct exam on Proctor, and they would like to drag him through on cross because from what I understand, he's stupid. The defense doesn't need Proctor so much as they need the asshole-ish attitude of Proctor to explain away the shoddy investigation that was performed by other cops in the text group. And so what they'll do is they've got a hearsay problem on all of Proctor's texts. They could authenticate and introduce them through Proctor himself by him saying, these are my text messages. I recognize them. I made them. And then they could examine and cross-examine him, which they don't want to do. Or they can instead bring up this guy who they just voir dired, who says he can authenticate and verify that these are an accurate representation of Michael Proctor's texts. And then what they can do is ask questions related to how those texts influenced his state of mind as he conducted a shoddy investigation once they established the foundation that the investigation was insufficient or done in some aberrant way. And then they can talk about the state of mind influence of, the text messages of Proctor and on this guy. That's a great way to get him in. It's really brilliant. If Bev will let them do it, she should, in my opinion, let them do it that way. I don't think she's gonna, though. I think she's going to force the defense to call Proctor, which they can do. They've got him on the witness list. They can call him. They'll get to treat him as a hostile witness so they can cross-examine him. But then the state gets to cross-examine him rather than subjecting him to direct. Direct is where the state doesn't want him to be. The state wants to put a leash on him and say, come on, be good and follow us, please. For the love of Christ, don't go off on your own. So, that's what just happened. We'll see what Bev rules on it. I think she'll rule in favor of the state because she has on like all of the other important decisions. Hope that helps if anybody was wondering what was going on there. It took me a little bit to kind of piece it all together on what their plan was. Sorry about that. You got to throw darts sometimes at these things and go, oh, yeah, there we go. All right, here we go.
Your Honor, this guy was caught texting dick jokes with his friends. The evidence will show that they also called out Kurt's micropeen.
No way.
We put in all my text messages sexing up Brian, and he has a micropeen like Kurt. We need to hear Proctor tell his buddies he has a micropeen too.
There we go. That's 30 micropeens for the stream. With that, guys, that is everything that we've got. I need to get out of here. I got to get ready for, I've got, like I said, I'll be streaming with Zia a little bit later tonight. Watch for the announcement of it on Twitter or whatever. And we'll see what else I put out. I'll try and get a recap video out later today as well. All right, guys. Thanks a bunch. Have a good one. Catch you soon. Peace. Peace.
He drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and Erlang. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out an Ardbeg, a bow, more of Lafroig. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Painting tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the poem better than Nick. So pour out a glass for the ones who have passed to make the love of